it could not come in the list. Therefore, I am drawing my Lord's kind attention. If
No, that will come coming 5 days.
That for that.
Yes, that is
So grateful, my Lord.
Yes.
Should he submit the memo or it will not?
No, it's not necessary. It's already I have told that it will come.
My Lordship, this is I'm for the MCL matter. This is the MCL challenging the method of calculation of compensation amount. There are 3 matters already been tagged each other, matter. And the Lordship posted to 17/2/2025 not listed. And my Lord, further one more, my Lord. The Honorable Supreme Court, by 3/1/25, directed to decide the matter within 3 months.
Okay, we give it.
Kindly fix it at this.
All right. Next week, yes.
This is the matter relating to regularization of service 2019 matter, old matter, finished complete.
Criminal appeal is not bail, you know.
Land acquisition matter.
Criminal appeal well after this.
Land acquisition matter, there is an interim order of the Honorable Court staying the entire process. In the meantime, the alignment of the canal has been changed. The petitioner's land is not being acquired. The petition has become insured.
Please give it.
No, the land acquisition. The last representative Honorable Court direction to file the document of power pattern. And the authority already released one source, more than one proceeding in favor of the power pattern.
Your Lordship, this is a matter against the order of the tribunal, Your Lordship, Central Administrative Tribunal, in which an order was passed to pay the duties for shouldering higher duties, Your Lordship. And since this writ petition is pending, hence the CP is also not being proceeded, Your Lordship. Even if I have succeeded, Your Lordship, Union of India has filed. Right. Matter was specifically adjourned to 17/2.
Okay.
Obliged, Your Lordship. Supplemental list, item number 1.
And in this case, the consolidated copy of read applications of it, they have not sought.
No, that interim application has not been allowed. This interim application has been perhaps filed for
to dispense with filing certificate copy.
No. There's a last order on 5/2/2023. Copy of the interim application has been sought after going through this one. Acha. That is allowed. So proposed amendment also shall form the part of the writ petition. All right. So consolidated writ petition has already been filed. Oh, you have not been served.
And the third item, the noting is rare portion is not available in the consolidated writ petition.
But बोले तो senior nahanti se इसमें 500 और मांगुଛନ୍ତି. Yes, sir. You want Passover?
କନସୋଲେଟର ଦେଇନାହାନ୍ତି ଆପଣ ଜାଣିଛନ୍ତି ଦିଆ ହେଇଛି କି ନାଇଁ
Passover କରିଦିଅନ୍ତୁ ଠିକ ଅଛି.
Item 2.
My notes are Yes, what do you say, boy?
There is a matter regarding rehabilitation appointment.
It's all right. The uh, division bench in the writ appeal has passed very detailed judgment, and what is so palpable error in it that you have filed the review petition for
My lord,
interference?
this honorable court has stated that there is a delay of 17 years.
17 years after the death of the government servant.
Yes, my lord.
Yes.
But the delay on the part of the petitioner.
That is not the sole ground. That is one of the ground. In paragraph 21, you are referring to. So that is not the sole ground. They have discussed the law on the different citations has been discussed, and
this matter
provision has been discussed, and apart from that, in the paragraph number 21, they have stated that the issuance of direction by the single judge while considering the respondent case for appointment on compassionate basis more than 17 years after the death of the government servant defeats the very purpose of the scheme. So, how you say that?
This matter is squarely covered under the Mohananda Sethi case.
Mohananda Sethi that has been discussed there.
Discussed, Your Lordship. The Mohananda Sethi case that the mother has filed no objection certificate and medical distress certificate.
When did she file that certificate? 7 years after?
After at the time of filing of the application by the petitioner, Your Lordship.
Yes.
After attending the age of 18.
At the time of death of the government servant,
Your Lordship,
mother did not say that she is not fit to take up the job.
Death took place in 2006.
Yes, sir.
28/6/2006. Now,
the only daughter, Your Lordship, only daughter. The petitioner is the only
daughter, only child.
Only child.
Where have you stated only child?
Yes, only child, Your Lordship. I have.
Yes. Where have you stated?
All along my writ application as well as.
Sure.
Paragraph 4, Your Lordship.
Because Mohananda Sethi specifically stated it is on the peculiar facts of the case.
After attending the age of 18.
Where?
I mean, paragraph 4 of my writ application, review application.
Not review. In your writ petition, where have you stated?
The application, Your Lordship.
If we come to paragraph number 4 of the writ appeal judgment, in that paragraph 4, it is stated that the respondent is the daughter of Parameshwar Majhi, who died on 28/9/2006.
Yes, sir.
While he was working as a junior stenographer, come typist under apparent number 6. On the death of her father, on the date that was, you are a minor, and after attaining the majority, you applied for the appointment under rehabilitation assistance scheme on 6/7/2030. So as such, it is 6 years. 6 years month the date of the date, but when you attended the became the major.
2012.
2012. So how this observation came that
Your Lordship,
17 years after the death of the government servant?
My Lord. Thereafter, Your Lordship, my application filed before the petitioner filed her application in the year 2013. Till 2017, no action has been taken by the authority in spite of several communication by the self-same authority to the higher authority. Thereafter, the petitioner approached before Your Lordship. Your Lordship directed to consider the case.
Where is your date chart for this review petition? Where is your date chart?
Yes, Your Lordship. Synopsis thereafter date chart, Your Lordship.
Yes. Okay, father of the petitioner died in 2006.
Main jinsada chhadidale when you applied. When you attained majority, when you applied, that you have left from the date chart.
Mother of the petition was
most vital hela seta.
requesting
6/7/2013. The petitioner filed an application before the Deputy Engineer, Supernath Irrigation Project for engagement in the post of peon, the rehabilitation assistance scheme.
Application is after mother's affidavit. Achi, tale achi. I
Please.
thought you have filed before
no,
that.
3/7/2013 I think.
3/7 mother affidavit ଦେଲେ
Uh,
ତାପରେ ସିଏ 6/7 ରେ ଦେଇଛନ୍ତି ଠିକ ଅଛି
In spite of that, may I submit you one document, Your Lordship?
ରୁହନ୍ତୁ
just a minute.
Okay, now you satisfy us why we should interfere in review.
My lord, only document.
ନାଇଁ my lord ନାଇଁ review ଅନୁସାରେ ଆମକୁ କୁହନ୍ତି
That the
Equational paragraph ରେ ଯୋଉଟା mention ହେଇଛି the date of the government.
କିଛି ଭଲ ମରିଲେ ସେ ସିଏ ଯେତେବେଳେ
ମରିଲେ
ହେଲା ତାପରେ apply କଲା
No, ମରିଲେ 2006 ରେ apply ହେଲା 2013 ରେ.
ହଁ
So how it is 17 years?
କୋର୍ଟ ଡାଇରେକ୍ସନ କଲା କେତେବେଳେ 2006 ରେ ମରିଲେ
ହଁ.
so death ରୁ calculate ହେଲା ନା 17 ବର୍ଷ
No. He has taken already steps for.
But why is this error of record on basis of ଏଇଟା ଠିକ ଅଛି reasoning may be wrong but why is it error of record because it says death
Actually, in the case of the petitioner on compulsion, 17 years after the
after the death of the year not that 17 years after application it is 17 years after the death so ସେଇଟା error of record ନାଇଁ error ମାନେ ଏଇଟା ଭୁଲ ହେଇପାରେ
the fault is not with the you see because she applied in 2013
yes
after she attended majority mother filed the affidavit so thereafter she is pursuing
no but why either error of record କାଇଁ ହବ so the direction by the court has been issued 17 years after the death of the government servant so it error of record is paragraph will not be
considerable.
the reasoning may be incorrect but not error of record yes you saying something କଣ କହୁଥିଲେ
Your Lordship, running page 39, Your Lordship, of my review application. Also, the same document has been filed in before Your Lordship in writ appeal as well as the writ application. The delay has already been condoned
where
by the authority concerned, the collector. Running page 39, Your Lordship. Annexure 7.
may be condoned at your level so ତାପରେ condone ହେଲା କି
Thereafter, Your Lordship, this Honorable Court of directed on 2016, running page 45, Your Lordship.
Government
Mr. Behra, if I remember correctly, you had been asked to file an affidavit to indicate that you are the only child.
Yes, Your Lordship. I also filed before the
Where is the affidavit?
writ appeal file ହେଇଥିଲା.
ହଁ ଦେଖ ଆଚ୍ଛା ରିଟ୍ appeal ଟା ମଗେଇଦବା ରିଟ୍ appeal ତ ଏଠି ଅଛି
ଅଛି writ appeal ବାହାରିଥିବ
ଅଛି ତା ପିଲା ରିଟ୍ appeal ରେ କୋଉଠି affidavit
तो लॉर्डशिप्स परमिशन में सबमिट वन
Just a minute.
ଆପଣ ଯୋଉଟା ପଚରା ହଉଛି ସେଟା ଆଗ କୁହନ୍ତୁ because we are trying to find out a way and as far as I remember you had been asked to file an affidavit ଟା ଦେଇଥିଲେ ନା ନାଇଁ
And look at 3.1 there, the respondent is the daughter of late permission, who is a minor at the
on
time.
21/8/2024 you had been asked to file an affidavit
yes sir
so affidavit ଦେଲେ କି
yes file in court
କୋର୍ଟ ଯେ
physical
କାହିଁ
units.
ସେଟା ସେ କୋର୍ଟରେ ଫାଇଲ କଲେ this is the problem ସ୍କାନ ହେଇକି ରେକର୍ଡରେ ଆସୁନି ଆମର ବି ସେ ଗୋଟେ disposed of application ଦେଖାଇଲେ because on the date they file it they are not scanning so it is not available in the record
But original year ଏଟା ପୁରା
ହଁ ଥିଲା ବୋଲି ତ କୁହାଇଥିଲା
କୋର୍ଟରେ ଦେଇଛନ୍ତି କହୁଛନ୍ତି।
କୋର୍ଟରେ ଦେଇଛନ୍ତି କୋର୍ଟରେ ଦେଲେ ସେ ଇନକର୍ପୋରେଟ ହଉନି ଆଉ ଏଠି ନାହିଁ କପି ଅଫ ଦ ଆଫିଡେଭିଟ ଅଛି ଆପଣଙ୍କ ପାଖରେ ଟିକେ ଦଳେଇବ ଆଉ ସେ ରିଟ୍ ଅପିଲ ଟା ମାରିଲେ ଷ୍ଟେଟସ୍ କିନା ଡକ୍ୟୁମେଣ୍ଟ ଫାଇଲ ହେଲେ ବି ତା ଦେହରେ ଏଣ୍ଟ୍ରି କରନ୍ତି ଅଫ କୋର୍ସ ଡକ୍ୟୁମେଣ୍ଟ ଫାଇଲ ଇନ ଦ ରେଜିଷ୍ଟ୍ରି ନଟ୍ ଇନ ଦ କୋର୍ଟ remember you had thinking of this
Yes,
that if
yes,
you are the
yes.
only child we will
Yes.
consider your case you had been asked to file
Yes.
affidavit
Thereafter you lordship hold that
oh say affidavit
we
copy
consider the case
yes affidavit କାଇଁ
affidavit ମୁଁ ପାଖରେ ନାହିଁ
ଫାଇଲ କରିଛନ୍ତି କହୁଛନ୍ତି
ଆଜ୍ଞା କୋର୍ଟରେ ଫାଇଲ କରି ସେଇଦିନ ସେମ୍ ବିଫୋର ଦି ଓଥ କମିଶନର ଦି ରେସ୍ପୋଣ୍ଡେଣ୍ଟ
ସେମ୍ ଡେ ତ ହେଇନଥିବ ତାକୁ ଡାକିକି
ନା
କରିଥିଲେ
ସେମ୍ ଡେ ରେ ଡକା ହେଇକି affidavit
ମାନେ 21st ରେ the order was passed you did it on that same day
no next day ଯୋଉଦିନ ଡେଟ୍ ଥିଲା ମୁଁ ତାଙ୍କୁ ଡାକିଥିଲି ସେଇ ଓଥ କମିଶନ ପାଖରେ affidavit ଫାଇଲ ହେଇକି ଫାଇଲ ହେଲା
How did you not keep that copy of the affidavit with you if you have filed it?
yes I have filed it.
ଏଇଟା ତ ପେପରଲେସ୍ ନାହିଁ ସେ ମାଗିଦେଲେ ଫିଜିକାଲ ରେକର୍ଡ ଟା ହବ ଦେଖ 20 ତାରିଖରେ ଥିଲା ପୁଣି ଆମେ 21 କୁ ରଖିଥିଲୁ ରିଟ୍ ଅପିଲ ଟା for that affidavit
ମୁଁ କାଲିକି ଯଦି ରଖି
Tomorrow you want it tomorrow?
ତୁମର ହବନି will ask for the record also ନା
ହଁ ତା ନାହିଁ ଦେଖନ୍ତୁ ମୁଁ ଆଣିବି affidavit ଅଛି ଘରେ ଅଛି ଅନ୍ୟ ଅଲଗା ଫାଇଲ ରହିଛି
ଦେଇଦେଲା ଭଲ
legal aid certificate ଟା ଅଛି page 25
କଣ page 25 ରେ କଣ ଅଛି
only
legal aid certificate
we are asking for that affidavit which we had filed because now we are going to review an order passed by the division bench what he has filed or not is different because of that he had been asked
This review petition has been filed. Review petition process. To probably preview the judgment of the order dated 13/1/2025 passed in WA number 777 of 2024.
ଆମେ ପାଟନ
ଅଛି
ମାନେ
ଆପଣ ପାଖରେ ଥିଲେ ହବନି we need the record
yes sir
otherwise ଆଉ ଗୋଟେ ବାଟରେ ଯିବାକୁ
ତାର ଜେରକ୍ସ ଟା
ଗୋଟେ affidavit ଅଛି purpose ସେଟା affidavit ଟା ଅଛି record ସେଟା କୋଉ purpose ରେ ଅଛି ସେଟା
ନା ସେ affidavit
କୁହା ହେଇଥିଲା ତ so record ଟା ଆସିଗଲେ ସୁବିଧା ହବ
it appears that the writ appeal was filed challenging the judgment of the order dated 31/10/2023 passed by the learned single judge in WPC number 1665 of 2023 17, whereby the learned single judge has allowed the writ petition filed by the petitioner of this review petition by setting aside an order whereby the petitioner's application for appointment under rehabilitation scheme was rejected. In the writ appeal, after discussing the factual scenario, also the decision of the Honorable Supreme Court, this court was of the view that issuance of direction by the learned single judge for considering the case of the petitioner for appointment on compassionate basis more than 17 years after the death of the government servant defeats the very purpose of the scheme of appointment on compassionate ground. The land counsel for the petitioner referred to the date chart and submitted that the father of the petitioner died on 28/9/2006, and the petitioner is the only daughter of his father, only child of his father, and she submitted an application before the executive engineer, Subarnarekha Irrigation Project, division number 2, Devudi, for engagement in the post of PM under the rehabilitation assistance scheme, along with other all necessary documents, on 6/7/2013. And prior to that, on 3/7/2013, the mother of the petitioner had shown an affidavit requesting to appoint the petitioner, who was her only daughter, under the rehabilitation assistance scheme. It appears that during the hearing of the writ appeal on 21/8/2024, the matter was adjourned on the prayer of the petitioner for obtaining instruction and to file an affidavit. It is the contention of the land counsel for the petitioner that the petitioner filed an affidavit which is dated 23/8/2024. केबे फाइल करथिला आपण
23/8/2024
in court.
डेट लिखन देनी भूल जाइयो एट फाइल रिपोर्ट
affidavit dated 23/8/2024.
पूर्ण फाइल लागू डेट नहीं
in खाली court हम छाड़ दो डेट परिवानी खाली डेट dated.
but the same has not been taken into consideration.
But the same has not been taken into consideration while passing the impugned judgment in the writ appeal. The Land Council further drew the attention of this court to the legal air certificate, which is with number page
25.
25. In the Etauchi writ appeal is rana. Or review petition in page 25.
Reader file कर रहे थे
आगे
करथिले तो
yes your
legal air certificate issued by the Tahsildar Baripada, which also shows that the petitioner is the only daughter, only child of the deceased government employee. Name is Parameshwar Maji. Yeah, it's a purpose record.
ଆସିଗଲେ ତାପରେ ଦେବେ ନହେଲେ ପୁଣି confusion as this affidavit is not available in the scan.
The affidavit stated to have been filed by the land counsel for the petitioner
In the writ appeal.
in the writ appeal is not on record.
Not available in the digital
Not available in the digital record. Let the records of writ appeal be placed on the next date, that is on this matter to be listed on 10th of March or 11th March 2025. You file this with
ସେଟା ଗୋଟେ line ଦେଇଦିଅନ୍ତୁ.
let the land counsel for the petitioner also file the copy of the affidavit with a memo.
You file it by tomorrow so that it can come on record.
Yes, sir. Before the register.
Yes.
Again.
କୋର୍ଟରେ ଦେଲା ବେଳେ ଥରେ ମିସ୍ ହେଇଯାଉଛି ରେକର୍ଡରେ ରହୁନି.
Your lordship.
Exactly. It's item number 1 came to Asila. Senior Asila ni. All right. Yes.
ହଁ ମ୍ୟାଡାମ କଣ କହୁଛନ୍ତି ଆଉ ଦିନ ନବା ତୁମର ଯେ କଣ ଗୋଟେ ସେ ଦେବେ ଘର ଗୋଟେ କଣ
No. You see, madam, the order was passed that you are to supply the consolidated copy to କହୁଛନ୍ତି ନାହିଁ ଆପଣ ପାଖରେ ଅଛି କି
ଷ୍ଟେଟ
ସେଇଟା
କାଉନସିଲ କୁ ଦେଇଛନ୍ତି then he will check up କୋଉ ଦିନ ଦେଇଛନ୍ତି କହିଦିଅନ୍ତୁ.
have you got the proof of that when you
ଆରେ ଆପଣଙ୍କୁ ଆପଣ ଅଫିସ ନ ଦେଲେ ତାଙ୍କ ଫଲ୍ଟ କଣ
କେବେ
କହିଦିଅନ୍ତୁ
କେବେ ଦେଇଛନ୍ତି ଆପଣ ପାଖରେ ଥିବ କିଛି ଡକ୍ୟୁମେଣ୍ଟ
ମ୍ୟାଡାମ ଫାଇଲିଂ ନାହିଁ ସର୍ଭିଂ ଅଫ କପି ସେଟା ଅଲଗା ଥିବ ତାଙ୍କୁ ଦେଖେଇ ଦିଅନ୍ତୁ ସେ ରିସିପ୍ଟ ନମ୍ବର ବି ଥିବ ଯାହା ହଉ ନଥିଲା ଆଉ ଥରେ ଦେଇଦେବେ ଆଉ ତାଙ୍କୁ ଦେଖେଇ ଦିଅନ୍ତୁ ରିସିପ୍ଟ ନମ୍ବର
ଫାଷ୍ଟ ଲାଗି ଦିଅନ୍ତୁ WPC number 30576 of 2024 ସେଟା ଆସନ୍ତୁ the land counsel for the petitioner submitted that as per the order dated 5/2/2025 passed in IA number 1902 of 2025 he has already supplied the consolidated writ petition copy to the land counsel for the state.
ମିଳିଲା
ଜାନୁଆରୀ ମାସରେ ଯୋଉ ରିଟ୍ ଟା ଫାଇଲ କରିଛନ୍ତି ତାର
ନାଇଁ ନାଇଁ ସେଇଟା ନୁହେଁ
31 ଜାନୁଆରୀ 2025 ର ରିସିପ୍ଟ
ସେଇଟା ନୁହେଁ madam, the order was passed on 5/2/2025 ରେ the land counsel for the state however submit that the copy has not been supplied to the is not supplied to him. Let a copy of the consolidated writ petition be supplied to the land counsel for the state during course of this week. Put up this matter next week or 11 तारीख.
ସାର୍ ଙ୍କୁ ପଚାରି ଜେରକ୍ସ କରି ଗୋଟେ ଦେଇଦେବେ.
This same order is to be passed ଆଉ କୋଉଟାରେ ଦିଆ ହେଇଥିଲା second ଟା
ଠିକ ଅଛି ଆଉ ଗୋଟେ କପି ଦେବେ କିନ୍ତୁ ଥାର୍ଡ ଟା ତାର ପ୍ରେୟାର ପର୍ସନ
ଆଚ୍ଛା ଠିକ ଅଛି ସେକେଣ୍ଡ ଟାରେ ସେମ୍ ଅର୍ଡର କରିଦେବେ ଯୋଉ WPC 30458 of 24 ସର୍ଭ କଲେ କୋର୍ଟରେ
ସେକେଣ୍ଡ ଆଇଟମ 30458
ଆଚ୍ଛା ସେକେଣ୍ଡ ଟାରେ ତାର ଲେଖି ଦିଅନ୍ତୁ
ପ୍ରେୟାର ପେଜ ଟା ଦେଇଦେବେ
he has supplied to the land counsel for the state in court. ପ୍ରଥମ ଟାରେ ଦେଲେ
ହଁ ଦେଲେ
ତାର ହେଇଗଲା ତ କି ଦରକାର ନାହିଁ
ନାଇଁ ମ୍ୟାଡାମ ଯିବେନି ରୁହନ୍ତୁ ଫାଇଲରେ ନାହିଁ ମୁଁ ଜେରକ୍ସ କରିକି ହଁ ଟାଇମ ଦିଆହେଇଛି ଥର୍ଡ ଟା ପାଇଁ ଶୁଣନ୍ତୁ ଅର୍ଡର
so you have received
ଦେଲେ ସେକେଣ୍ଡ ଫାର୍ଷ୍ଟ ଟା ଦେଇନାହାନ୍ତି 576
ସେ ତ ଦେବେ କୁହାହେଇଛି ଆପଣ ବୁଝାବୁଝି ହେବେ
କପି ଦେଇଦିଅନ୍ତୁ ମୁଁ
ବାସ୍ ବାସ୍
ଜେରକ୍ସ କରି ଡିପୋଜିଟ୍
third ଟା ଲେଖନ୍ତୁ the land counsel for the state has pointed out that though he has received the consolidated writ petition copy but the
ଅଫିସ ନୋଟିଂ ଦେଇଛି
अच्छा ऑफिस को भी नोटिस
ହାଇକୋର୍ଟ
ओहो
ମ୍ୟାଡାମ ତୃତୀୟତାରେ ଯୋଉ ହାଇକୋର୍ଟ ରେ ଯୋଉ ପେଟିସନ ଟା ଫାଇଲ କଲେ ଗୋଟେ ପେଜ ଛାଡି ଦେଇଛନ୍ତି
affidavit portion ଟା ଛାଡି ଦିଅନ୍ତୁ
ଲିଷ୍ଟ ଟା ଦେଖନ୍ତୁ କଣ ଲେଖା ହେଇଛି ବୁଝିଯିବେ
କିଛି ଦେଇନାହାନ୍ତି କପି ନେଇଗଲେ ସବୁଟା ଏଥର ଦିଅନ୍ତୁ
no it is not in proper order the prayer portion is not available let us see
ଦେଇନାହାନ୍ତି
prayer portion ଟା ନାହିଁ prayer person टा छाड़ दी जंती हाँ so number 3 रे जोटा the office has pointed out that the consolidated writ petition filed at flag B is not in proper order, that is the prayer portion is not available in the consolidated writ petition. Let the land council for the petitioner rectify the defect as pointed out by the registry and also supply the same to the land council for the state. Yes. So all these three matters will come next week. So first and second, you have already, we are mentioning that you have solved. देना चलता होता है ठीक है नेक्स्ट
Item 3.
ये 11:25 चलते है ना endowment. Yes, item 3.
My lord, I am appearing for NHI in this matter. I filed my vocal command, but my name is not been reflected in the court title.
No, where is the counsel for the petitioner? Archana Mahanti. Files written with our appearance, no, but that has not. His name is not reflected.
That's not a problem, but say the none of you is going next to the
So, you, what is your good name?
And Santosh Kumar Divedi.
You are appearing for
OP4, your lords.
OP4,
my lord.
OP4 means Project Director, National
Highway Authority. NS.
Let's see, Mr. Santosh Mahanti.
Santosh Kumar Divedi.
Santosh Kumar Divedi, Land Council submits that he has filed the Wakalatnama
Yes, sir.
for the opposite party number 4 and stop. Let the Wakalatnama be placed on record. The name of the Land Council appearing for the opposite party number 4 be reflected in the cause list henceforth. Stop. None appears for the petitioner put up this matter. Put it with the
Item 4.
Mr. Divedi, you had been asked to get instructions whether that amount had been deposited or not.
I'll see them.
So remember that. Get that
definitely.
next week. Is order dated those three. First week, fourth quarter. Okay. Okay, sick. Last page.
Last page.
The second last paragraph.
The Land Council for the opposite party number 4 shall obtain instruction in terms of the order dated 28/1/2025 regarding deposit of money with the opposite party number land acquisition officer from competent authority of the National Highways Authority of Orissa, Chhatrapur, Ganjam. As per the order passed by the District Judge Ganjam Baram in SPJC number 3 of 2018. এটা দেখি লিখ দেবে order dated 28/1/2025 ର third page ରେ ଅଛି ହେଲା second sub paragraph. Yes.
Next week.
Next week. I'll leave this matter next week.
11.
Yes, item number 4.
One Passover.
Passover.
Item 5.
My lordship, last 55 years, one revenue appeal number 6571 has been pending before the suppletor purpose.
Which one?
My lordship.
What is your prayer?
Prayer, my lordship, early disposal. My lordship,
RA number 60. What is this RA?
Array number, my lordship, 65,571.
No, what is the full form of RA?
Revenue appeal, my lordship.
Revenue appeal.
Appeal.
It is pending before the sub-collector.
Sub-collector. My lordship.
From 1971.
My lordship. In this regard, already 2 read petition has been filed. My lordship, on dated 18/5/2016 this lordship, the honorable court directed to the sub-collector Panpost to dispose of a array number 65 of 1971 as expeditiously as possible. And my lordship, page number 31, when the read application has been mentioned, bearing number 497/2019. In this read petition, this honorable court directed to the sub-collector to dispose the matter expeditiously as possible, preferably within a period of 6 months.
No, this is the first one, Annexure 3, which was disposed of on 18/5/2016, is your first read petition.
My lordship.
Second read petition order came.
My lordship, the order passed by the sub-collector in page number 51, my lordship. In this page,
50?
Sub-collector could text. Page number 31. This order has not been reflected in website, my lordship.
Okay.
The same order has been reflected in the page number 31.
So last order sheet upon kebe kar deychandi?
Ita my lordship jota am petitioner file karthla meta annexure 3 re my lordship mu annexure
18/7/2023, that is at page 41.
18/7/23, yes. Notices issued to so and so. Receipt of notice. 20 numbers are present and filed. Hajir heard them and PG in election was 1/8/2023.
Yes, tested to 1/8/2023.
You write the matter in spite of 2 orders of this court. ଆପଣଙ୍କର election duty ଅମକ duty ସବୁ ଲାଗିକିନି ଆପଣ ଗୋଟେ 71 ର matter
No. There good substitution is taking long. So notice judge se appear karnanti, that is let him get instructions.
18
Because he is given the order sheet dekhananti.
And 18/7/23 was the last order sheet.
Tapare last order sheet ye deichanti. Tapare post 16/7. Tapare post on ye achi 1/8.
1/8 ର ଥିଲା hearing ପାଇଁ. Instruction. All right. This writ petition has been filed by the petitioner Prakash Agrawal for a direction to the opposite party number 3, Sub-Collector Panpost Raurkela, for concluding the proceeding in RA number 65 of 1971 within a stipulated period. The Land Council for the petitioner drew the attention of this court to Annexure 3, which was the first writ petition filed by the petitioner in WPC number 24953 of 2014.
1971, which is pending, you are not a party there because you bought the land in 2016.
16 I am also added as a party in array number 64.
No, I'm asking you a question. Please listen to it and answer. You were not a party in the proceeding which started in 2071.
No, ma'am.
You have bought it in 2016. Thereafter, you have approached. So, what is your grievance regarding some proceeding which is pending?
No, my lordship. My lordship, I am jaha pakru kinilu. Ye my lordship as a party. Yes, my lordship.
Yes. So, that is why. Not that he is the
not,
petitioner.
You have not stated that this was filed by the petitioner. It is that in which he is a party.
He has subsequently been added as a party.
So and so, in which the petitioner has been subsequently added as a party. तापर लिखले ना WPC number 953 of 2014, order dated 18/5/2016, in which this court directed the opposite party number 3 to dispose of RA number 65 of 1971 as expeditiously as possible. This writ was filed by you.
My lords.
Okay. It further appears from the order dated, who order ta dekhouthile jo
31, my lords.
31. It further appears from the order dated 15 to 2019.
4 to 2019. 4 to 2019.
15/2/2019 ନା ଯୋଉ ଆର ରିଟା ସେକେଣ୍ଡ ରିଟା ମେନସନ ହେଇଛି।
ହାଇକୋର୍ଟ ର ଅର୍ଡର ଟା ହଉଛି 4/2/2019। ସବ କଲେକ୍ଟରଙ୍କର ଅର୍ଡର ଟା ହଉଛି 15/2/2019।
ସମସ୍ତେ ସେଇଆ କହୁଛି। It appears from the order dated 15 to 2019 of the opposite party number 3 that another writ petition was filed in WPC. एटा के फाइल करछन? Yes, Land Council.
Chudamani Ponda. Chudamani Ponda.
Chudamani. Acha. Filed by one Chudamani Panda, which was disposed of on 4 to 2019, in which similar order has been passed directing the opposite party number 3 to dispose of revenue appeal number 65 of, I think revenue appeal number 65 of 1971 expeditiously, preferably within a period of 6 months from the date of production of the certified copy of the order. The Land Council for the petitioner has annexed the order sheet of the sub-collector Panpos in the aforesaid RA number so and so, and the last order sheet is dated 18/7/2023, which indicates that the case was posted to 1/8/2023 for hearing.
ନୋଟିସ ଟା ବି ମଧ୍ୟ ସବୁ ସଫିସିଏଣ୍ଟ ଏଥିରେ ଦେଖା ଯାଉଛି ମିନିମମ୍ 32 ଜଣ ଲୋକ ଅଛନ୍ତି ତା ଭିତରୁ 21 ଜଣ।
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଆଣନ୍ତୁ। We know that ଏଇ ଯୋଉ ଯାଇଛି ନୋଟିସ ଟା ଇସ୍ୟୁ ହେଇଛି 32 ଜଣକୁ, 32 ଜଣରୁ 21 ଜଣ ସେଦିନ ଆପିୟର କଲେ, ହାଜିରା ଫାଇଲ କଲେ। ତ ଆଉ ଯୋଉ 10 ଜଣ ରହିଗଲେ ତାଙ୍କ ବିଷୟରେ କିଛି ଜଣା ପଡୁନି। ତ ଆପଣ 10 ଜଣ ନା 11 ଜଣ ରହିଗଲେ, 11 ଜଣ। ତ ସେ ବିଷୟରେ ନେଇ ଆସନ୍ତୁ ଆପଣ। Let the Land Council for the state obtain the status of the RA number. Free copy of the order be handed over to the Land Council for the state. Eta rakhuchu 17 tarikh dino. You are getting 2 weeks time. Place this matter in the week commencing from 17th of March 2025. Yes.
specifically 18 को रखे लगा।
अच्छा 18 कर दे। 18 कर दे। 18/3/2025।
डेट दे दो लिस्ट में टुकड़ा।
Item 6.
You are now listening. What is your good name, Land Council?
Niranjan Behra.
Or Mr. Niranjan Behra.
My lord, in Annex 5, there is an omission to add the limitation petition. Although there is specific amendment in paragraph 14, but there is omission to add the limitation petition. So that's why I have filed IA to add the limitation petition in the writ petition and a consequent.
No, it is there. Page number 40, the limitation petition is there.
No, that is in another appeal. That is in appeal number 2. But it is in OA appeal number 17.
Just a minute.
My lord, kindly see 14, paragraph 14, page 11.
Paragraph 14 of your writ petition?
My lord, page 11.
Just a minute.
My lord, kindly see copy of such OA appeal memo number 17 of and limitation petition. Filed under section 5 of the Limitation Act for condonation of delay is herewith enclosed as annexure 6.
Annexure 6
ମାଇଲର
କଣ ହେଲା?
ସେଥିରେ କିନ୍ତୁ ଲିମିଟେସନ ପିଟିସନ ଟା ଆଟାଚ କରନି ଯୋଉଟା କି
ଆଚ୍ଛା ଆମେ annexure 6 କଥା କହୁଛନ୍ତି।
ମାଇଲର
annexure 6 ରେ ଆପଣଙ୍କର ଅପିଲ ମେମୋ ହଉଛି OEA ଅପିଲ ନମ୍ବର 17 of 2021 ତା ଦେହରେ ଆପଣ ଲେଖିଛନ୍ତି with limitation
ମାଇଲର ସେଇଟା ଆଡ କରନି ଲିମିଟେସନ
ଲିମିଟେସନ ଟା ଆଡ କରିନାହାନ୍ତି କିନ୍ତୁ
ଲିମିଟେସନ
ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି ଯେ it is with limitation ସେଟା ହଉଛନ୍ତି ପାରାଗ୍ରାଫ ନମ୍ବର କେତେରେ ଦେଖଉଥିଲେ
14
paragraph number 14
ତାମାନେ you only want to
add actually add କରନି
amend your index.
index and also read the page ଟା change
କୋଉଠି ରଖିଲେ ଆପଣଙ୍କ petition ରେ ଦେଖିଲେ? petition ରେ କୋଉଠି ଲେଖିଲେ?
ଖାଲି index page ଟା ଲେଖିଲି
ଦେଖିଦିଅନ୍ତୁ I might have missed it, you check.
ଆଜ୍ଞା
You cannot give a consolidated petition ଯୋଉଠି schedule of amendment ରେ those amendments are not there. Might be there, I may have missed, just check.
schedule of amendment that in the index page of the read petition at serial number 9 of the description column after the word copy of the OEA appeal number 17 of 21 the words and connected limitation petition be added and consequently in the column of page number 42 to 45 be deleted and in that place 42 to 46 be inserted
এটা তার মানে এটা হবো annexure 6 সিরিজ হবো
ଆଜ୍ଞା ସିରିଜ
ହବ କାରଣ ଆପଣ ଯଦି ଲିମିଟେସନ ପିଟିସନ ରେ ଫାଇଲ କରିଛନ୍ତି ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି in paragraph number 14 that copy of the OEA appeal memo and limitation petition filed under section 5 of the limitation fact is annexed to with annexure 6 but annexure 6 ଟା ଖାଲି ହଉଛି
ଯଦି ଅଛି ତାହେଲେ ଅସୁବିଧା କଣ ହେଲା ଆପଣଙ୍କର ଗଭର୍ନମେଣ୍ଟ ରେ ଅଛି so you don't need to
limitation petition ଟା ଦେଇନାହାନ୍ତି
exactly so I was asking ଯଦି ସେଟା ଦେବେ ଗଭର୍ନମେଣ୍ଟ ର ଦରକାର ଗଭର୍ନମେଣ୍ଟ ରେ ଅଛି ଏଇଠି ଭୁଲି ଯାଇଛନ୍ତି ଗଭର୍ନମେଣ୍ଟ ରେ ଅଛି ତ ନହେଲେ ପୁଣି confusion ହବ you satisfy yourself you don't need to amend your amendments
no only to add that
page 10
ନାଇଁ ଠିକ ଅଛି ଆପଣ ତ ପଢିଲେ ଆଉ
so have you filed any interim application in that respect?
My lord
which is that
3287
but we should not advise you but for you're correcting your index you don't have to file an amendment you could have made a prayer and you would have allowed you to substitute the index because the index is not supported by an affidavit but since you have done it it is darkar nahi taku kariya pe you could have just given a corrected index
annexure 6 like this it's a 6 series habo so that is why perhaps
but seta the body re nahi so this is not necessary strange thing that to amend the index kona ye darkar nahi you just permit him to replace the
index re khali likha hota and limitation petition
page number guda debe
page number bhi change he jibo apan
seta କହିଛନ୍ତି accordingly येटा भी कर देबे केना स्कैनिंग हे जायथिबो ता
पूरा कंप्लीट सेट होते देले
हां so that would be better lekon IN number so and so there is an application for amendment of the first title of the writ petition
first title there is nothing there is no prayer for amending the index मोर भूल लिखि देला first title index लिखिया कथा हो ठीक अछि चलिबो since we will allow you to replace your index it is all right
however the land council for the petitioner submits that the index space is required to be replaced
due to some
omission
yes
the land council for the state has no serious objection in that respect so prayer for amendment
not necessary not necessary
land council is permitted to replace the index space giving copy to the land council for the state as well yes I is disposed of
তাহলে কমপ্লিট সেট দেবে না পেজ মার্কিং করিবে কোন
পেজ
কমপ্লিট সেট তে দেবে
সেট সব দিটা কোড রে রেখে দিলে সুবিধা হবে
কমপ্লিট সেট অফ annexures ঠিক আছে লিখে দাও
complete set of annexures shall be there and matter be you do it during course of this week so that it can come
within
next week.
course of
Matter listed on 11th of March 2020.
How do you read them?
Asha.
Office will be on.
All right, 18 March. 18 March. Yes.
Item 7.
Yeah, please.
Date and 19.
This is the second time joining before your lordship. Sir, the collector has rejected my grievance petition for payment of a revised rehabilitation assistance under Annex 9. The running page 44, your lordship.
ତିଆରି କରିକି engineer. What is wrong with the order?
Yes, sir. Wrong. Yeah.
What is wrong?
Collector has hold that there was no house at the time of acquisition of a land.
Yes.
That is illegal as because your lordship.
Vigilance inquiry.
Annexer 2, your lordship. Running page 25.
Yes.
10/12/2002 at the time of acquisition of a land.
This is after 2002. Okay.
2, your lordship.
Yes, yes.
At the time of acquisition of a homestead land.
Yes.
There is a notice
Yes.
where the name of the petitioner was reflected.
Yes.
There is the house of the petitioner was there.
Where?
My lord.
Where is the house?
Upon the acquired land, your lordship.
Where is it written?
Running page 49, running page 26, jail number 48, 49, your lordship.
26.
My name is.
Your name is there. What about the house?
এই ঘর বিষୟରେ ଏଇ ଘର ପାଇ ଘର
ପଢନ୍ତୁ notice ଟା ପଢନ୍ତୁ.
ଆଜ୍ଞା ଏତଦ୍ୱାରା ମୌଜା ପେଣ୍ଡ୍ରାବନ ଥାନା କୋମନା ମାନଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ନିମ୍ନ ଇନ୍ଦ୍ର ଜଳସେଚନ ପ୍ରକଳ୍ପ ଦ୍ୱାରା ବାସଚ୍ୟୁତ ହେଉଥିବା ପରିବାରଙ୍କୁ ବାସଚ୍ୟୁତ ହେଉଥିବା ପରିବାରଙ୍କୁ ଥଇଥାନ କରିବା ପାଇଁ ଚିହ୍ନଟ କରାଯାଇଅଛି. ଏହି ସୂଚୀ ଅନୁସାରେ ଯଦି କୌଣସି ଯୋଗ୍ୟ ବ୍ୟକ୍ତି ତାଲିକାରେ ଅନ୍ତର୍ଭୁକ୍ତ ହୋଇ ନଥାନ୍ତି, ଇଏ ଯାହା ତାଲିକାରେ ଅନ୍ତର୍ଭୁକ୍ତ ହୋଇଛନ୍ତି ଆଉ ଯିଏ ନଥାନ୍ତି ତାହେଲେ ଆମ ପାଖରେ ପିଟିସନ ଫାଇଲ କରିବେ. That the petitioner already there, your lordship.
There you have been given compensation for being there. You have been given.
My lord, I don't know.
ଆପଣ ସେଠି ଥିଲେ ବୋଲି ଆପଣ compensation ଦିଆ ହେଇଛି.
Compensation
ବାସ ମାନେ କଣ stay? ବାସ doesn't mean house.
ହାଉସ ଲର୍ଡସିପ ଏଇ ଯୋଉ ରିହାବିଲିଟେସନ ଆସିଷ୍ଟାନ୍ସ ସେଇଥିପାଇଁ ଦିଆଯାଉ ଯୋଉମାନଙ୍କର ହୋମ ଷ୍ଟ୍ରିଟ୍ ତା ଲ୍ୟାଣ୍ଡ ଯାଉଛି. Thereafter, lordship, this document also I have also the another document, your lordship. Form 10 notice has been issued where the house of the compensation of the house for the construction as given to the petitioner, your lordship. Running page 52. ଘର ଟଙ୍କା ଯୋଉଠି ଘର ଟଙ୍କା ଅଛି ମିଳୁଛି ସେଠି ଘର ଥିଲା କଲେକ୍ଟର କହିଲେ ଯେ ସେଠି ଘର ନାହିଁ. ଆଫ୍ଟର 2008 ପରେ ସେମାନେ ଘର କରିଛନ୍ତି ବୋଲି କଲେକ୍ଟର କହୁଛନ୍ତି. ତେଣୁ ସେମାନଙ୍କୁ ରିହାବିଲିଟେସନ ଆସିଷ୍ଟାନ୍ସ ଦିଆଯିବ ନା. ଆମକୁ ଘର ଟଙ୍କା ମିଳିଛି. ଫର୍ମ 10 ଇସ୍ୟୁ ହେଇଛି, ଫର୍ମ 9 ବି ଇସ୍ୟୁ ହେଇଛି. Apart from that, your lordship, one
Go page annexure 10.
annexure 10 running page 52 your lordship.
Running page 52. আপনার নাটা কোথায় আছে?
হ্যাঁ নাটা আছে
52.
সেটা আবার আমার খাতাটা 239
ঠিক আছে 52.
খাতা নাম্বার 239 না সেটা
52 হ্যাঁ
ରନିଂ ପେଜ 52 ଗୋଟେ କଲମ ଅଛି ଘର ଟଙ୍କା ଆମକୁ ମିଳିଛି
ସେ ଘର ଟଙ୍କା ମିଳିଛି ପୁଣି ଆଉଥରେ କଣ ମାଗୁଛନ୍ତି ତାହେଲେ
ଘର ଯୋଉ ରିହାବିଲିଟେସନ ଆସିଷ୍ଟାନ୍ସ ଯୋଉ ଅନ୍ୟ ଜାଗାକୁ ଆମେ ଯାଇକି ଘର କରିବା ପାଇଁ ଆମକୁ ଯୋଉ 7 ଲକ୍ଷ କି 2 ଲକ୍ଷ 5 ଲକ୍ଷ ସେମାନଙ୍କର ସ୍କିମ୍ ଅନୁସାରେ ଅଛି ସେଇଟା ମିଳିବା ପାଇଁ ଆମେ କହୁଛୁ ସମସ୍ତଙ୍କୁ ପାଇ ଅନ୍ୟ ଲୋକମାନଙ୍କୁ ଦିଆହେଇଛି ଆମକୁ ବି ନୋଟିସ୍ ଇଏ ଲର୍ଡସିପ୍ କାହିଁକି ସେ 2023 ରେ ଗୋଟେ ନୋଟିସ୍ ଇସ୍ୟୁ କରିଛନ୍ତି 2023 ରେ ରନିଂ ପେଜ 37 38 ରେ ଆମ ନାଁ ଅଛି ତମେ ଆସ लिस्ट रे अछि हमगु रखिछन रनिंग पेज 38 33
ପାଣି ହେଇଗଲା 12 17 56
56
ହଁ ସେ ପାଣି ହେଇଗଲାଣି ପାଣି ପଶି el paso
apart from that annexure 5 your lordship
this all right this writ petition has been filed by the petitioner challenging the order dated 31/1/2025 passed by the Lenin Collector and District Magistrate Mohabbat in rejecting the representation filed by the petitioner. In which prayer has been made. What was your representation?
For getting up the rehabilitation as revised rehabilitation as
for payment of revised payment of revised rehabilitation and resettlement assistance under the displaced family category under the provision of Orissa R&R Policy 2006 on acquisition of land for construction of Lower Indra Irrigation Project area. The Land Collector has held that since the petitioner could not prove the existence of the house over Khata number 239, Mauza Kendra Ban during the acquisition of the land in the year 2000, the genuineness of the claim of the petitioner could not be established. Accordingly, the claim of the petitioner for grant of R&R assistance under displaced family category on the basis of 9B register prepared in the year 2008 cannot be considered at the belated stage. Land Counsel for the petitioner referred to the notice issued by the notice issued under Annexure 2. So also, I would account the
annexure 10 you also form 10 annexure
so also annexure 10 the form
annexure 11
also annexure 11 which is form number 10
form number 10
in which the and submits that these two documents would substantiate that there was dwelling house in existence when the land was acquired, and therefore the order passed by the collector and district magistrate Noapada is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice
For all opposite parties.
on behalf of all the opposite parties. Extra copies of the petition be served on the Land Council for the state. Matter will be listed after 4 weeks. Counter affidavit if any be filed in the meantime. Giving copy to the Land Council for the petitioner. Yes.
9 and 10, Your Lordship.
Same. See,
Same.
see, annexure very same.
Same.
9 and 10, same. Yes.
Item 8.
It's not here. And then the annexure 1, my lord, which is in the name of petitioner's father, my lord, for acquisition of his only homestead land, my lord, for widening and strengthening of the NH 26.
Yes.
And in the meantime, the father of the petitioner died. I have annexed the death certificate,
Yeah.
annexure 3. But again, the OP4 Land Acquisition Authority issued notice number 49 of 24. The pending of one LA 122, they have issued LA number 49 of 24 against the dead person, father of the petitioner. And the land in question is the only homestead land and where three-story building is standing. You will also have a glance at annexure 4 at
no say notice to seat ପାଇଁ issue ହେଲା ଯେ national highway ର ଏଟା ପ୍ରଶସ୍ତିକରଣ ପାଇଁ ଏଟା ଦରକାର ଅଧିକରଣ ହେଉଛି ସେଥିପାଇଁ କ୍ଷତିପୂରଣ ବାବଦ ଏଇ ଡକ୍ୟୁମେଣ୍ଟସ୍ ଆଣିକି ଦିଅନ୍ତୁ ସେ ଆସେସମେଣ୍ଟ କରିଦେବେ ତେଣୁ ଏଟା after receipt of the notice you must have filed the documents.
Yes, I have filed. I have also filed the ROR and.
What has been done? Have you got the compensation amount?
No. That matter has been pending till now.
Yes.
But in the meantime, his father of the petitioner died. Again, another LA notice has been issued against me, against the father of the petitioner.
No, it's all right. LA number 49 of 2024. When this notice was received by you, which was in the name of your father, so you should have pointed out that my father is dead, because the authority might not be knowing that about the death of your father.
What happened, my lord?
Yes.
You lordship have a glance at page 11. So I have filed an objection under subsection 1 and 2 of section 30 of National Highway Act regarding not to act, last para of that page 11. That objection petition has been posted for different dates. During that period, my father died. After that, another LA matter has been
Mr.
filed.
Sahoo, you filed the objection or your father filed the objection?
My father filed.
Yes. So why are you saying I have filed?
No, I'm saying, my lord, that my father filed the objection. Now, LA number 49 of 24 at annexure 4 filed for same thing, same.
It's all right. It has been filed and you have already received the notice. You have approached the authority. So ultimately, you have to get the compensation, the legal heirs of this South.
There is my objection is there, my lord, in a past LA case number. And I have no knowledge as after my death of my father, I have no knowledge about LA 49 of 24.
Now you are having knowledge, you have annexed this document. So you are having knowledge. So what steps have been taken?
Already that highway has already passed in before my building, my lord.
Yes.
Still my building is 10 feet back of that
highway, my lord.
No, now they require it now for the
Not
expansion.
required, my lord. It's not required to acquire.
You cannot say they say it is required. So there must be a plan, and that area you are just only to get the compensation. That
No, that is not my story. But my objection is that my only building is there, and that highway has already been constructed. And then
they are not disputing that the highway has been constructed. It is for expansion of the highway.
That expansion has been completed, my lord. Completed. A representation. After knowing that this LKS 49 at Annex 4, LKS now 49 of 24 has been filed, I have also given a representation before the OP4.
Proceedings before the court, what representation?
My lord, 22 substitution application ଟା ଦେଇକିରି objection ଟାକୁ ନିଅନ୍ତି।
My objection କରୁଛନ୍ତି।
Objection ଟା ଏପର୍ଯ୍ୟନ୍ତ
substitution
I have given the
49 they would have very well filed an application for substitution, and then also whatever your objection you could have filed, but you have filed a representation.
They have not disposed of that.
Case is pending before the court. How can they deal with your representation?
They may acquire my land at any point of time. So
this case is pending before which?
Before OP4, the additional Tahsildar competent authority for land acquisition.
Pending.
Instruction not
pending proceeding, petitioners should apply for a substitution, should file a substitution application, and that proceeding should continue. And if they have filed another mistake without realizing that it is against his father, he takes objection there and say that this case is pending. I am filing a substitution application there, and
everything he has to do it in that proceeding, not in the representation.
That's exactly what is to be done.
Direct direction may be given for disposal of that representation.
Representation that will not.
Then you will also be direct filing of substitution petition, and until that period, no action.
No direction is necessary. You are to just withdraw it and apply for substitution. Your father was there, is a party. In that
I have filed a death certificate before the competent authority, but they have not till date considered that matter. But not
an
passed
application
any
is to be
order.
filed for.
Where is the application which you have filed there?
Representation, my lord.
No, please don't refer to the representation. What application have you filed with that certificate you are saying? Death certificate you have
Death certificate I have annexed that.
Death certificate you have annexed.
18,
but
18.
What have you filed in the proceeding?
My representation is there. I have no knowledge as my father had died.
अरे से कथा केते थरो कहिबे फादर डायड मोर डेथ सर्टिफिकेट
तो जानि नथिल ना
ए गोटे प्रोसीडिंग आपनकर बापा जो थरे पक्ष सेटा पेंडिंग अछि बेली आपन कहउचंती दैट इज आल्सो पेंडिंग सो व्हाई आर यू नॉट गेटिंग सब्स्टिट्यूटेड इन दैट पिटिशन प्रोसीडिंग
सेतबेले सेटा जानि नथिली
ठीक अछि एबे जानिले
तो लिखि दंतु दिस petition has been filed so and so. After arguing for some time, the land council, the petitioner, seeks permission to withdraw this petition. To file appropriate application for substitution in the pending proceedings. Accordingly to the petition.
Till that period, within 1 month, I will file. Till that period, no course of action will be taken.
Yes, next.
That is only that.
Yes, next.
Item 11.
No, this is relating to renewal of the Khasmahal beach in Puri, Balukhand area. I prepared a small lecture. We have given one in the reflection. I'm doing a chat today. Even Lordship can go through the facts, sir. I just bless this chat.
What is your prayer in this petition?
My prayer is, very simple facts and the background. Grandfather of the petitioner had got a lease in Puri in the year 1930. And that lease was supposed to be renewed in 1955. The grandfather passed away, he didn't make any application for renewal. He had 4 sons. So there's a partition being made. One of the shares belongs to the father of the petitioner. So father of the petitioner applied for a renewal of the lease in 95. Lead application was processed. A report was also submitted to government, and no action was taken. Again, petitioner again applied for renewal. That renewal application pending. But in respect of other courses, it's already been settled. I have the documents that. So my application has to be disposed of by the collector.
No, but in your date chart on 9/1/2023, you have mentioned that the general proclamation was issued by the opposite party number 3, directing the petitioner and other co-sharers to vacate the lease.
They have made a general proclamation, but
if it has been already settled in the favor of the co-sharers, then why proclamation was issued?
One of the co-sharers, it has been settled. Another 2 co-sharers, their applications are pending.
So where have you stated in your date chart that it has been settled in favor of so and so?
In the petition.
And who is Santosh Datta?
Santosh Datta is my cousin, my father's brother's son. So that letter, in fact, we had that letter.
No, in the date chart there is nothing.
No, date chart in the petition paragraph.
Petition?
Also mentioned. That's it. Paragraph 10 minutes. Page 9. That in the meantime, a portion of Sadiq plot number 1183, corresponding to HAL plot number 60, has been directed to settle in favor of one of the co-owners, namely Sukumar Datta, in accordance with the family settlement arrangement. However, the application of the petition respect to the other portion of the said plot, which had fallen to the share of his father, is yet to be settled.
In the meantime means when?
In fact, that letter had not got there. I have got that letter
in the document.
Yeah, I have document. I have to. I'm afraid to hand it over like this because I got it later. As you can see, I'll give you a correct copy because I have not got this letter when I filed the petition. You have typed it legibly. Let's see the typed copy.
This is before coming into force of that amendment.
Pardon?
So this is before coming into force of that section amendment to section 3(4).
Yes, we in fact that is the basis of our claim, and that's it. That's our right. Fourth, Notwithstanding anything to the contrary contained in the proceedings of sections of any law, any customs, practice, or uses having the force of law, any land to the category of Khasmahal. This Khasmahal is admittedly Najrul, Gramkhantha, Parabok and Abadi, wherever situated and used for any purpose, may on application be permanently settled with heritable and transfer rights with a person who is in occupation of such land either on the basis of lease or otherwise for a period of at least 3 years prior to the appointed date in such manner and subject to payment.
You are reading?
I'm reading Orissa, this OGLS land, section 4.
OGLS rule section 5BG.
No, first I read the section, then I'll go to 5B. This is section. Section 3, subsection 4.
Yeah.
This is the provision. Notwithstanding anything to contrary contained in the proceedings of sections or in any law or in custom, practice, or uses having the force of law, in the land of the category of Khasmahal, Najrul, Gapkanta, wherever situated and used for any purpose, may on application be permanently settled with heritable and transferable rights.
You are reading 3-4.
3-4, which was brought by amendment. Now, Justice Ratho pointed out that amendment. This is that provision.
No, সেটা ওটা পরে হয়েছে ওটা পরে।
5B section. Rule 5B. Rule 5B also, lots we can see.
Rule 5B, there's some notification.
Yes. Notwithstanding anything contained in Rule 3, 5, 5A, 8, 11, 12, 13, settlement of Khasbahal and Rajul land, leased out and Gramkantha, Parapswanso, Abadi land occupied prior to 26th day of February 2006 and used for homestead purpose shall be made in the manner prescribed in Schedule 5. Ultimately, they will take the decision. Ultimately, they take the decision. They have not. They have proceeded on my application. One document and so minutes to satisfy this, that I satisfy these two provisions, Annex 8. An RI report was collected on the basis of the application given by us is in the Annex 8, page 55, to show the entire history of this lease and our application. Annex 8, page 55.
Okay.
Page 61.
Right.
Then
what is the status of this application?
I've given the order sheet on next page below. Last order 22/6/2018. Case at page 63 minutes. Case record is put up today. Petitioner is present. RI report is not received. Directed to RI Valikonda 108. Submit report immediately. Hence the case record is put up after receipt of RI report. It's in that state till now. No, this is latest certified copy of which the date will be available. The certified copy itself.
कौन से केस नंबर कौन पूछेंगे B.K
BKS means Balukhand settlement.
अच्छा बालूखंड से
Settlement. That area, Chokothor road area is called Balukhand area.
BKS case number 28
of 2018.
Okay, start to see.
Pending but eviction notice will be required. So, eviction notice,
If Lordship have to look at the settlement they have done in favor of my origin, have given. So it will be easier to. I've given that document.
no, that is before amendment. No, if you file an application
In
that
fact,
is pending.
I rightly said, amendment gives a better status, clarity.
Because anybody in possession can apply.
And regarding possession, I given a document, the RI report in respect of this particular, and on my father's application, gives detailed history of the leach.
Like this petition has been filed. Mr. Lakshmidhar Pangari and senior advocate filed the appearance memo, which is taken on record.
So
Yes.
who's there with you?
Swaraj. Swaraj?
T.S. Swaraj.
T.S. Swaraj.
Is also submitted date chart, which is taken on record. The writ petition has been filed for Swaraj. Land Council, Land Senior Advocate, referring to Annexure 9, submits that on the renewal application filed by the petitioner,
10.
Properly, 9 submitted, so and so. BK's case number 28 of 2018 was initiated, and the order sheet of the said case has been annexed to the writ petition as Annexure 10, and it is the contention of the Land Council that the last order was passed by the Tahsildar Puri in the said case on 22/6/2018, wherein the direction was issued to the RI Balikond 108 to submit the report immediately, and the matter was directed to be taken up after receipt of the RI report. It is the contention of the Land Council for the petitioner that the RI report has not been received.
No.
This
is last order, sir.
The RI report has not been received. He further submits that what is the name of that man?
Our co-sharer is there.
The co-sharer, Sukumar Dutta.
How they may record the pending or
he has also submitted one document relating to the renewal of Balifond Kasmal 108 lease land in respect of Sukumar Datta, and it is stated that he is the co-sharer. Let the Land Council for the state obtain instruction regarding the status of BK's case number 28 of 2018. Put up this matter. केबे रखियो फोन तो 2 weeks. This matter will be posted 24th of March 2020. Yes, what further you require?
In fact, that the general proclamation should not have included our name. It has included our name because our application is pending. Normally, in a case where the lease application renewal is pending, they should not put for eviction.
So what is your interim application?
For that. But the interim application let it lie over because they are not proceeding because they know my application is pending. They are not proceeding. Let it lie over.
Commissioner purchase.
25, 3, 20.
Ah.
We are just coming.
Item 12.
Wait, please, Millards. Let's hear the OP number 1. Millards was appointed on a short-term contract. If Millards will kindly see page 26, annexure 2. Millards has page 26, Millards. Yes, Millards, dated 30th January 2014, Millards. The appointment is clause 1, Millards. The appointment is purely temporary for a period of 6 months from the date of joining or until further orders, whichever is earlier. Clause 6, Millards. The engagement in no way entails responsibility of NIFT Bhubaneswar for permanent absorption appointment of to any post based on this offer. The appointment can be terminated by either side without assigning any reason after giving 1 month's notice or 1 month's salary in lieu thereof. So, Millards, this arrangement continued for a while till the point when the OP number 1, Millards, sought regularization of his services before the CAT, Honorable Central Administrative Tribunal, Millards, for which it filed, the OP number 1 filed OA. Millards, your Lordship will see page 53. The original application was filed. OA number 260 by 236 of 2021. Millards, may kindly just see the prayer, Millards. Page 67. Directions, quash the letter dated such and such. Directions be issued to the respondents to regularize and absorb the applicant in the post of computer engineer with effect from 30/1/2019. That is the date he completes 5 years service on contract basis, and allow the regular scale of pay in the pay scale attached to the post. When this OA was moved, Millards, and interim order was passed before the Honorable CAT, Millards, at page 69, Millards. Dated 12/5/2021. Millards sees the date of the order, Millards. On the next page, Millards, that interim order is there at the top. Insofar as passing interim order is concerned, while granting 4 weeks time to the respondent to file their objection, if any, to the prayer for interim, it is directed status quo as on date insofar as continuance of the applicant as computer engineer shall be maintained till next date, which is fixed to 7/9/2021. So, Millards, that interim order was granted. Millards, may kindly take page 125 for a moment, Millards. This, Millards, as your Lordship saw, it was for a period of 6 months, the appointment. This arrangement was continuing. Fresh appointments were being issued to him with whatever service breaks they were being given. Last such appointment, Millards, is at page 125. Millards will see para 1. The engagement of service of Shri Dinaballabh Sahu computer engineer is for a period of 6 months from the date of joining, that is 6/4/2021 forenoon to 5/10/2021 afternoon, or until further orders, whichever is earlier. So this is the last, Millards, contract. And para 5, Millards, the short-term contract may be terminated at any time by giving 1 month's notice or 1 month's salary in lieu thereof, either by the employee to the appointing authority or by the appointing authority to the employee. Millards, may kindly note that it can be terminated by virtue of 2 conditions, either by giving him 1 month notice or by giving him 1 month salary for that notice period, Millards. And again, clause 6, Millards, it clearly says that he is not entitled, he can't seek entitlement for regularization. Then, Millards, the final judgment in the OA is passed on 10/12/2024 at page 71, annexure 7, Millards. Annexure 7. Now, Millards, may kindly take page 75 onwards is the finding. If may I just read that 1 page, Millards. The ad hoc service was also extended with a odd, the last para, Millards, page 75. The observation of the Honorable CAT. The ad hoc service was also extended with a order dated such and such, and so on. It is seen that in the advertisement, the age criteria for the post of computer engineer was stated that the candidate should be within the age of 25 to 40 years and 5 years relaxable in the case of NIFT employee, and deserving candidates possessing higher educational qualification experience. It is not in dispute that the applicant was not a regular long-term contractual employee of the NIFT, and further it is not in dispute that by the cutoff date of advertisement, he was 45 years, 10 months, and 16 days, and therefore, even after giving relaxation of 5 years, he will not be eligible to appear before the selection as per the advertisement. Another important aspect which needs to be looked into is that in the representation, his prayer was to convert my short-term contractual employment to long-term contractual employment in due scale of pay of computer engineer in NIFT. In the OA, he has prayed to quash the order of rejection wherein his prayer to grant him age relaxation was rejected and to direct the respondents to regularize and absorb him in the post of computer engineer with effect from 30/1/19. Therefore, it is seen that the prayer of the applicant in the representations and in the OA are totally different and and thus the very approach before this tribunal in the OA is hit by section 20 of the Administrative Tribunals Act. Besides, the apex court in the landmark decision in the case of Uma Devi was pleased to held that regularization of contractual ad hoc and daily wages employees are impermissible in law, as it would offend the provision enshrined under Article 14 and 16 of the Constitution of India. We have also gone through the decision relied by the applicant in the case of NSK Nair. We find that the facts of the said case is different from the facts of the present case. Hence, the same is distinguishable and is not applicable to the present case. Hence, going by the decision of the Honorable Apex Court in Uma Devi and the decisions of the coordinate benches of Jabalpur bench and Guwahati bench, we find no merit in this OA, which is accordingly dismissed. So, Millards, his attempt for regularization is dismissed. And Millards, your lordships have already noted, the last such contractual employment was till 5/10/2021. Thereafter, after this judgment, Millards, was uploaded on 10th December 2021. On 11th December 2021, in the next page, Millards, at page 78, Annexure 8, his services were terminated on 11th December 2021. Against this termination, Millards, he files OA 769 of 2024 before the Honorable CAT, which Millards will find at page 82. And this OA is filed on 24/12/2024, Millards, after the termination. And your lordship will kindly take the prayer of that OA, that is at page 100. Let's have prayer, the prayer clause. Prayer 1, set aside the impugned termination order such and such dated 11/12/24 issued by respondent by holding the same as illegal. Direct the respondents to reinstate and allow the applicant to continue in his former post of computer engineer forthwith. So, Millards, once his attempt of regularization has failed, he is trying to achieve the same indirectly by saying holding the termination as illegal and allow him to continue henceforth. Then, Millards, what was the order passed by the Honorable CAT, which is at Millards page 102 on 30/12/2024 during winter vacations. Page 102, Millards, Annexure 11. Let's have page again. Millards, I'll just read the last para, Millards. As far as interim relief is concerned, since prima facie at this stage it is found from the impugned order that no notice of 1 month or salary in lieu thereof has been given to the applicant before termination of his contract, the impugned order dated 11/12/2024 shall not be given effect to, and as a consequence, the applicant shall be allowed to continue as he was prior to the impugned order till next date, by which time the respondents are to file objection to interim relief. So, Millards, retrospectively, the order of termination has been stayed by the Honorable CAT, which is directly in the teeth of all the laws, as has been propounded by the Honorable Supreme Court in service jurisprudence, that an order of termination cannot be stayed because it amounts to usurpation of public office without having a right thereof. That is the judgment, that's a settled proposition of law as laid down by the Honorable Supreme Court. Now, Millards, thereafter, I file MA number 8 of 2025 and IA for vacation of that interim order, Millards, at page 104. And Millards will see what I stated in that. It's very important, Millards, at page 8, para 8, Millards, page 109. However, in the interregnum, it is highly imperative that the interim order dated 30/12/2024 be kindly vacated on the following grounds. First is, he is no more entitled to a regularization in the post of computer engineer. Second, without prejudice, it is submitted that even at the highest, if this tribunal is of the final determination that the applicant was indeed entitled to 1 month's notice or salary in lieu thereof, then the respondent institute can readily make the payment of the said notice period salary to the applicant. In fact, for this reason, respondent institute is undertaking to deposit the said amount with the registry of this tribunal subject to outcome of the OA 769. However, in any event, allowing the applicant to continue in the post, which he is not otherwise entitled to, as per the calculation, without prejudice, it is submitted that the applicant's 1 month salary is arrived at 38,500, which amount respondent institute is ready and willing to deposit the same in the tribunal without prejudice and subject to outcome of OA 769. Para C, it is also reasonably contended that a continuation of an anguished employee like the applicant would be to the detriment of the respondent institute, inasmuch as it would also mean allowing him to have unbridled access, because Millers is a computer engineer, unbridled access, which is highly prejudicial to the respondent institute. It is also submitted that even when the applicant was enjoying the earlier interim order of 2021, there have been serious disciplinary violations on the part of the applicant, for which even show cause notices were issued. The highest possible outcome or interest of the applicant in the present way would be if this honorable tribunal holds that he was entitled to 1 month's notice period as salary in lieu thereof, the very interest of the applicant is duly secured by deposit of the salary. This, Millers, is, and para E, lastly I say, there is the mandatory ingredients of a Millers interim order, that Millers a prima facie case, a balance of convenience, irreparable injury. All three have to be satisfied. None of them were satisfied. Therefore, kindly vacate the stay is what I have prayed. Then Millers, pleadings were also completed. I filed the reply and at page 136, the reply also has been filed on 10th of January. Interestingly, Millers, and rejoinder also has been filed on 24th January, which your lordship may kindly note this order, page 160, annexure 17. Learned counsel for the applicant submitted that he has filed rejoinder and objection to the MA. So he has also filed rejoinder. The pleadings are complete. When that MA 8, which was vacation of stay, moved, the Honorable Cat holds, Millers, at page, this is the impugned order, Millers, at page 167, dated 7th of February 2025. Millers, before the Honorable Cat, I cite judgments of the Honorable Supreme Court, where Supreme Court has clearly said that it amounts to usurpation of the public office and should not be stayed. Millers, may kindly see page 169. This is of the impugned order at page 4, at para 4, Millers. I'm sorry, Millers. I'm so sorry. Learned counsel appearing for the respondents by reiterating the standpoint taken in the MA objection has placed reliance on the decisions of the Honorable Apex Court in the cases of State of Uttar Pradesh and others versus Sandeep Kumar Balmiki and others, and State of Haryana Suman Datta. And similarly, learned counsel for the applicant by reiterating his standpoint has placed reliance on the order of the coordinate bench of the Jodhpur bench. Then, Millers, your lordship will kindly see page 172. Para 8. Admittedly, 1 month's notice or 1 month's pay in lieu thereof, as provided under the statute, has not been complied with in this case. Further, the respondents have stated that if it is held by the tribunal that the applicant is entitled to 1 month's salary, they are ready to pay the same through this tribunal. But how far on such payment the order of termination shall be validated is a question that will be decided only after filing a regular counter. The counter filed rejoinder. We also find that the decisions filed by the respondents have no application insofar as deciding continuance or otherwise of the ad interim order. Hence, we do not see any justification to vacate the ad interim order, which is made absolute till final disposal of the OA, which can be done after completion of pleadings. Plus, the matter was being part heard. Rejoinder also has been filed. The pleadings are complete. And now they say after completion of pleadings. Hence, call this matter on such and such date, awaiting completion of pleadings after filing of the counter and rejoinder by the parties. Now, everything is fine.
The date is fixed to 21/3/2025.
Yes.
So it's for final hearing. But further you want.
Malats, what is happening? A person is being, Malats, before your lordships.
This is stop the thinking, then that is like this is the mind of the administrative tribunal who shall go to the matter. Because we go in the matter is already subjudice, counter file, affidavit, rejoinder file. So, and the date is fixed to 21/3/2025.
Malats.
So you can trace for that on that date is disposed of.
May I respond to your lordship's query?
Yes.
Malats, here on the issue of whether the termination is legal or not, Malats, I beg your lordships, Malats, may not venture into that. But Malats, insofar as passing of an interim order of stay of the termination, that interim order could not be passed. Malats, this is Malats, the judgment of the Honorable Supreme Court, which adds. Saate dui re pass hela, it's dated Saate dui, but that day when arguments were concluded, it was reserved. We got it later on, the order, which Malats, that is Malats, I am not. 7/2/2025. Malats, may kindly take just these two judgments, Malats. I am Malats saying, what is his case at his hands? He will get 38,500 if my termination is illegal. He'll get that. I am depositing that money in court. But let him know, he's a computer engineer, Malats, and your lordships knows what is the capacity of computer engineers, Malats. I am not saying so.
We are not entering into the merits.
Yes, I am not. I am Malats, begging your lordships not to enter into the merits. What I am saying, Malats, is that interim order cannot be granted. That is why this judgment, Malats, so far as it has travelled challenging it.
What interim order was passed?
This is the interim order, Malats. Your lordship, kindly take the interim order, which is passed at page 102. Annexure, Malats, 11. May I please, Malats?
Now, the applicant shall be allowed to continue.
Yes.
If as he was prior to this one, so.
That is something he has been rejected in the earlier way. He is achieving that through this process. And therefore, Malats, this judgment of State of Haryana versus Suman Datta, your lordship must be having 2010 SCC 311. This appeal by the State of Haryana is directed against an interim order passed by the High Court of Punjab and Haryana.
Or which has been passed on 7/2/2025.
Yes, and
of course 30
again. 30 बार भी I have to challenge. The reason, Malats, is
you are ready for that date to argue the matter.
I am ready, Malats. I'll ready and finish. In fact, Malats, I'll let me.
21/3/2025.
It is not reflected in the order, Malats, but I have said so in my petition. Matter was actually being heard what the honorable cat said.
Where it is mentioned that the counter and the rejoinder file will go to the
Agia. First order Milots will see at page 147.
Counter or rejoinder file each will look.
Your Lordship wants to see that order recording.
Order.
Agia. Page 147, annexure 14.
147. Okay.
Ethere Koichi Lare Council for Respondents, that is us, Milots, submits that he has filed counter and MA number 8 of 25 for vacation of interim.
Then rejoinder
ଲେଖା ହେଇଛି 24/1/2025 order ରେ page 160 annexure 17
2025 ର ଆଉ ଗୋଟେ ହଉଛି କୋଉଟାରେ
24/1/25 annexure 17
2025 annexure 17
ଆଜ୍ଞା.
When was the interim order passed? When was the interim order of stay passed?
30/12/24 and your lordship will see the expeditious manner in which we have prosecuted this. The pleadings were complete 30/12 order pass hela, pleadings completed in 24 within 25 days. We have not wasted any time. In fact, Milot, your lordship, I have stated that in my writ petition that matter was actually being heard on final release. Setabale kon hela, what they do, your lordship, I have stated that they moved an amendment application to the OA after completion of pleadings.
They are delaying the matter. So
yes. So I pray, Milot, see ebe kon hobo Milot 23/1 they will press for their amendment. That there. I have mentioned that. Para U, page 15. On the next day, 30/1/25, the matter was finally heard on merits on OA 769. The petitioner, that is us, made his arguments and concluded. For conclusion arguments of the OP number 1, the matter was adjourned to 7/2. However, shockingly, instead of arguing the matter on the final merits,
all right. This writ petition has been filed by National Institute of Fashion Technology, Bhubaneswar, challenging the orders dated 30/12/2024 and 7/2/2025 passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 769 of 2024. The Land Council for the petitioner submitted referring to Annexure 7, which is the judgment and order dated 10/12/2024, passed in OA number 256 of 2021, which was filed by the opposite party number 1, Dino Sahoo, wherein he has prayed for regularization of the service, and the said OA was dismissed. The Land Council submits that after the pronouncement of the judgment, termination order was issued against the opposite party number 1 on 11th of December 2024, which was impugned by the in the OA number 769 of 2024 by the opposite party number 1. And while entertaining this original application, the London Tribunal has been pleased to pass the first order টা কেবে করেছে 30/12/24 that is আচ্ছা 1911
আগে
has been pleased to pass an order dated 30/12/2024 as an interim measure that the impugned order dated 11/12/2024 shall not be given effect to, and as a consequence, the opposite party, number one, shall be allowed to continue as he was prior to the impugned order till the next date. The Land Council further submits that the petitioner entered appearance in the said case and filed an application for modification of the order,
vacation
vacation of the stay, vacation of the interim order passed, which was registered as what is that MA number?
MA number 8 of
2005. However, the London Tribunal disposed of the said MA on 7/2/2025 in dismissing the same and calling the matter on 21/3/2025, awaiting completion of pleadings after filing of the counter and rejoinder by the parties.
and made that order absolute also.
And also, where is that absolute order?
80 page 172 রে para 8 রে লেখা আছে
right, and that
which
order
is made absolute till final disposal of,
and the interim order passed on 30/12/2024 was made absolute till final disposal of the OM. The Land Council for the petitioner submits that in the impugned order dated 7/2/2025, though it was mentioned that counter and rejoinder affidavits are yet to be filed, but the order sheet dated 13/1/2025, so also 24/1/2025 would indicate that not only the counter affidavit, but the rejoinder has already been filed. The Land Council further submits, referring to the judgment or order passed by the Honorable Supreme Court in case of State of Haryana versus Suman Datta, reported in 2010 Supreme Court cases 311, that the if by an interim order an employee is allowed to continue in service and ultimately the petition is dismissed, then it would amount to his usurpation of the public office without any right to the same. The another decision the Land Council for the petitioner has placed reliance, that is in case of State of Uttar Pradesh versus Shandip Kumar Balmiki, reported in 2009, 17 Supreme Court cases 555, wherein it has been held that the interim order passed by the High Court in staying the order of termination of service is not permissible. That is the word used, no?
again para 5 para 5 and 6, because it amounts to granting of final relief at the interim stage.
As it would amount to granting final relief at the interim stage. Both the decisions are taken on record. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Let extra copy of the writ petition be filed, served on the Land Council for the Union of India, So far as opposite party number 1 is concerned, speed post requisites for issuance of notice so also be filed within a week. IA number 3367 of 2025 for the Land Council for the petition. There shall be stay of the operation of the impugned orders dated 30/12/2024 and 7/2/2025 passed by the Land and Central Administrative Tribunal in way numbers, what is that, MA number, so and so, until further orders. It is made clear that pendency of this writ petition before this court would not be a bar for the Land Central Administrative Tribunal to take up the final hearing of the, what is that number?
OA 769 of 20.
ON 769 of 2024 on merit, as it seems that the pleadings are complete.
That is keeping it to any date.
It will come after 4 weeks.
Obliged.
Yes.
Item 13.
13. Wait, please, Your Lordship. Here, my lord, the land of the petitioner.
Yes.
Lord, the land of the petitioner was acquired in the year 2004 for the mining project in the area of Talche, my lord. After this acquisition, my lord, the petitioner has received the compensation in lieu of the land and also in lieu of the structure, my lord, in 2005, my lord. After this, he has also got the rehabilitation assistance. The only grievance of the petitioner is he has not received the resettlement assistance, which has to be given to him, because similarly situated persons in Annexure 5, my lord, they have received the compensation in lieu of resettlement assistance. The only case of the petitioner is that he has to, my lord, the resettlement assistance he has to be given by the opposite party number 2, my lord, the authorities, my lord. And he has represented before the authorities since 2004 after the acquisition, in 2008, in 2016 also. He has represented before the authority recently, my lord, under Annexure 4 in page number 26, my lord.
2008 means 16 years.
My
You
lord.
have waited before coming to this court.
Yes, my lord, because he was in job through the rehabilitation scheme. He has superannuated from service in 2022. And throughout the process, my lord, he has represented before the authority. This is a fact, my lord. He has come to this court right now for the resettlement scheme only. But he has received in the process all the other benefits. So he has waited for the authority to only grant him the resettlement scheme, my lord. And he has given, my lord, previously
the list of the persons who have got the benefit that you have annexed as Annexure 5.
My lord, that lordship may see at the top it is mentioned as resettlement status of the village Baluga Khamar. That is the, my lord, village of the petitioner also, where the land has been acquired. So the only grievance of the petitioner, if your lordship will kindly see page 26, he has requested the authority to grant him the only resettlement scheme, because
your name doesn't find place here.
No, my lord. That has been left out arbitrarily. That is my only case, my lord. I have mentioned that in page number 26.
You got appointment under.
My lord, the rehabilitation scheme.
Page 17, so that is the
My
appointment.
lord, that is the appointment, and I have been superannuated from service in recently.
Representation.
Lord, may I submit one thing, my lord?
Yes.
At the cause title, my lord, there is only one error, my lord, typographical error. The authority who has to, my lord, consider the representation, that is opposite party number 2. That is MCL through its general manager, that has been mentioned Bharatpur area. My lord, that should have been Lingaraz area, in which the land has been acquired. That is an error from my side, my lord.
It used to be which area?
Lingaraj area. That is mentioned in page 26, my lord. The authority has also received the same authority.
Memo file
Body of the petition, have you stated
My lord,
anywhere?
that I have said that the land of the petitioner is from Lingaraj area, and the authority who has received and
No. Regarding description of opposite party number 2, have you stated it correctly anywhere in the petition?
No, my lord, no, my lord. That I have not done, my lord. Representation was rightly, my lord, to the authority of Lingaraj area. And the authority also received, my lord, the same authority.
You file a memo.
The
Writ petition has been filed by the petitioner Manranjan Mishra inter alia with a prayer to consider the representation dated 29/4/2024, which has been filed before the General Manager Lingaraj area Talche. The Land Council for the petitioner submits that
problem is, if the right person is not the party, then you how will you issue a direction to that person? Then I'll take it. Or a superior or a chief and go to a chief officer.
Representation
False title on record, it has to be
at the outset, the Land Council for the petitioner submits that inadvertently in page 2 of the writ petition, opposite party number 2 has been wrongly described as Mahanadi Coalfields through its general manager, Bharatpur area. Talcher on board. Instead, it should have been general manager Swanson at Lingaraj area.
Lingaraj.
And therefore, he may be permitted to correct this one. So, you correct it, permission is granted. And you put a short signature and the date today. All right.
Great.
Huh? Let's say said online file. Okay.
Then you file that scanned copy. You corrected page number 2. You file it. We are writing that you are filing this. All right. He files the.
Scan
the Learning Council for this one. So files the corrected
Post title.
Page number 2. Corrected post title. Stop.
Same shall be scanned.
How we dispose of
record correction
do it. We'll take up this matter day after tomorrow. Put up this matter day after tomorrow.
So that you get it with the proper cause title, then it will be effective.
Oh, bless.
Yes.
Item 14.
No, 14.
Put a password. Password direct. Item number 4.
Password item number 4.
Yes, Mr. Lenka.
May I please? Lord, here the order resuming the leased land in favor of the petitioner are under challenge. But the land was leased out in favor of the petitioner, who is an ex-army personnel. So that land was settled in his favor in the year 2004. I have also annexed the entire order sheet while leasing out the land in
No,
favor
we
of
are going to your date chart. So you have stated that one Japan lease was granted in favor of the petitioner
Yes, ma'am.
in 2003.
In 2003.
Yes, then what happened?
Well, in the year 2021, he wanted to sell the land in question.
Yes.
He presented the sell deed before the sub-register, who is also the ADM, who was also in charge of the sub-register. That was not accepted, and thereafter he approached the Honorable Court in the writ petition, and direction was to accept the sale.
Where is that order?
And that order I have not annexed, but I have disclosed about the sale. According, along with that order, I again placed the deed for registration. Thereafter, the ADM directed the Tahsildar to cause an inquiry and to submit the report. Thereafter, my lord, the rejection proceeding was started. Your lords will get the notice. Annex 3 is the ROR issued in my favor, pursuant to the lease granted. Page 30. Thereafter, your lords will get Annex 4 series is the certificate which forced the petitioner to sell the land, and accordingly under Annex 5 page 33, I made an application before the collector for grant of permission to sell the land. Thereafter, my lord, under Annex 6, that is the order dated 22 December 2021, a notice was issued to me to show cause as to why the land shall not be resumed on the ground that I have not used the land for the agricultural purpose.
Yes, then what happened?
Thereafter, I filed my show cause. Annex 7 is my show cause. Detailed show cause I have filed. But without considering that, my lord, the lords will get at page 51, a part of Annex 8. The land was resumed. Though my specific case is that I was using the land for horticulture purpose, and I used the same since the date of lease, at least till 2019. That was not accepted, nor I was given an opportunity to adduce evidence to that effect. And it was resumed, and thereafter it was sent to the sub-collector for approval, and subsequently the sub-collector sent it to the collector for approval. And the collector, without considering anything, and your lords will get at page 52, Annex 9, confirm the said order of resumption. Challenging that order passed by all the authorities, I approached this Honorable Court in WPC number 18103 of 2022, page 11. Sorry, Annex 11, page 54. This Honorable Court directed that there I took a plea that the confirmation made by the collector is not correct, because collector is the appellate authority. So my right to appeal became illusory. That is why your lordship was pleased to dispose of that petition, directing the petition to prefer appeal before the RDC. Thereafter, filed the appeal before the RDC, and without considering my case in proper perspective, the RDC also has rejected the same. That is Annexure 12. The findings by the RDC at page 60.
Yes. Which are the lines which you say, according to you, that the RDC has committed wrong?
The RDC committed the wrong in the sense, my lord. In fact, the land was never leased out in my favor under the OGLS Act. But now it has been resumed in view of the notification under section 3 of OGLS Act, which is not applicable to me, because since the land was never
what is the lease deed? What is the lease deed? Let us
lease annexure 2, my lord.
You mean to say the lease which has granted to you cannot be resumed under any circumstances?
It can be
Under what?
not under OGLS Act.
Then under which act?
If it is a Jawan lease according to you,
Yes.
then under which provision the lease is granted and which
It was under the lease principle. It was under the lease principle it was granted. So under that provision, it can be, the power can be exercised. That is also the decision of this honorable court.
Lease principle or Government Grants
Government
Act?
Grants Act.
Lease principle or Government Grants Act?
Government grant 1985.
Government Grants Act ର provision ଥିବ ଯେ when it can be resumed. ଆପଣଙ୍କୁ ଗୋଟେ lease ଦିଆହେଲା ଯବାନକୁ, ଆପଣ ଯଦି ଗୋଟେ particular purpose ରେ utilize ନ କଲେ, is there no other provision that it can be resumed? And if it is contrary,
No,
then
it can be resumed. Not
no. Please show us the provision. If you are not ready in that way, you can take up this matter some other day.
Your philosophy called next week. I will
Next
prepare
week.
a chart so
Alright.
that it can be.
After arguing for some time, the Mr. Linkal and counsel for the petition for an adjournment. Please, this matter, let it be on 11th, or you want more time? 11th next Tuesday.
11.
Or 11th of March 2025. This is to be stayed tomorrow. It will come tomorrow. Here?
I'm actually
Appeal bail. Please give it. Okay.
Ilvalan କହିଥିଲା ବୁଝେଇ ପାଇଁ ହଁ informant.
Item 9, my lord, the direction was given for appearance of the informant.
Is the
Supplemental list, item number 1.
May I please? 3 appeals arising out of one PS case. Appeals of the PS. And initially 6 persons were arrested and forwarded. Subsequently, 2 persons arrested. That is why GR case A, B, and these things are there. That is why 3 cases.
No, how many persons faced trial?
9 persons.
9. No, 6 it is mentioned in the judgment.
Judgment, first judgment 6. There are 3 judgments.
Oh, I see. No, you tell us about the first one. But the name are same. Lakshmi Gowda.
Lakshmi Gowda is the victim, my lord. The husband has been murdered. This is a case where
just a minute. It is a
informants, the victims appeal. Victims appeal.
Just a minute. So
accused persons have been acquitted by the learned line.
So in the first case,
yes,
as it appears, the ST case number is 56 of 2018.
Correct.
And 6 persons face trial, and the offences are under section so and so. And all of them have been acquitted.
Yes.
That is why you have filed this criminal appeal.
Ma'am.
So
judgment is same day.
Okay, but all the 3 judgments are pronounced on the same day, but for different accused in the same case, arising out of one
same PS case, different A, B, GR, because they were asked.
So, what is the proposal of the state? Whether you intend to file any to take instruction?
Let the notice be served.
No. Let the state instruction obtain the instruction,
because there are
This criminal appeal has been filed by the appellant Lakshmi Gowda under section so and so, challenging the judgment and order passed by Lenin so and so in ST case number so and so in accusing the respondents number 2 to 7 of the charges under section so and so. Let the learned counsel for the state obtain instruction as to whether there is any proposal from the side of the state to challenge the judgment and order of acquittal or not. Put up this matter. We commencing from 24th we are keeping. We are getting time. Similar order in the connected cases. List this matter along with so and so.
24th of this
24th of March 22. Yes.
Item 2.
May I please your lordship, my lord, offence under 302/34 IPC. After completion of trial court additional session judge Hon'Ble pronounced judgment of sentence 30/1/2019 convicted against appellant is sentenced to undergo life and
Mr. Tripathi.
Yes, my lord.
This Smruti Ranjan Mahapatra is your associate.
My lord.
Smruti Ranjan Mahapatra is your associate. You have filed Wakalatnama in this case. Let us see that Wakalatnama. No, the Wakalatnama is in the name of Asutosh Tripathi, means you and Parthasarathi Tripathi, right?
Yes, sir.
What we find that a prisoner's petition has been received in which a prayer has been made for engagement of Smruti Ranjan Mahapatra. Oh, that's Smruti Ranjan Mahapatra. Oh, I see. No, I thought it's all like that. So let us see that. You might not have been aware of it.
ଆଗରୁ ଦେଇଥିବ ସେଟା।
ହଁ 2023 ସେ ଲେଖିଥିଲେ।
ଜଣେ ଦବାକୁ ପଡିବ ସେ
we have to communicate it. You do one thing, Mr. Mahanti. the request was made to engage Mr. Smrutiranjan Mahapatra in place of Ashutosh Tripathi. And some reason has been given, whatever it may be. So let that person appear through virtual mode from the concerned jail. We'll tell him that about these things, about the sad demise of Mr. Mahapatra, and we'll give an opportunity to him to engage some other counselor, made a request on that behalf. Right?
Date may fix.
We are let him review the prisoner's petition dated 16/3/2023, in which a request has been made to appoint Advocate Smrutiranjan Mahapatra in place of Ashutosh Tripathi. However, since Mr. Mahapatra is no more, let the Land Council for the state instruct the concerned jail superintendent to ensure the appearance of the appellants. Jone appellant to adire Manoj Behera. Manoj Behera alias Kuntu through virtual mode. Which jail he is now?
Kuntuli jail.
Atmali. So it can day after tomorrow it can be done.
Kuntuli jail. Kuntuli Kotak.
No, it is the Wakalatnama has been signed from Atmali jail, and the prisoner's petition has also been received from Atgad jail. So,
next week mailers so that we can also take the views.
ए खुंटुणी जेल अच्छी बोली आपण कोड पाइले खबर
पक्ष लोक अछंती
वकालत न आठगड़ जेल खाई next week
dates may fix.
So let it be on 11th. 11/3. Mr. Tripathi, it will come on 11/3/2025. We are asking that appellant to appear through virtual mode, and we will apprise him that this Mahapatra is no more. If he says that he will continue with you, there is no problem. We can proceed. All right? Yes.
Item 3.
May I please, Your Lordship, file the present IULRC 6/7/2025 for interim bail of the appellant number 2, Your Lordship, whose grandmother died on 28 February, Your Lordship. So after his parents has already died, the only wife and a younger brother. Kali court
somebody was present, I think. First hour. তুমি কইছিল আমি ইনস্ট্রাকশন নেই ইউ বলি yesterday he made a mention in the first hour, and we asked the learning council from the state to obtain instruction.
Three hours there is
Instruction ଅଛି ସରପଞ୍ଚର ଲେଟର ଅଛି, obviously death certificate ତ ଆସି ପାରିବନି ଏତେ ଶୀଘ୍ର.
What is the offense?
302, Your Lordship. 302 life conviction.
There are 3 persons. He is moving for 1 person.
ଯାହାର
Yes,
ये mo gale आई gale na jejema gale
Jejema, grandmother.
grandmother am bujhuti
grandmother
ଦେଖିଦବା କଣ instruction I verification that ascertain that father of Kantha Muduli, petition number 2, have 3 brothers, Jaya Muduli, Aram Muduli, and so on. So the father Lakshmi and the mother have expired in October and November respectively. His grandmother na kon se jo
Kantha Muduli.
कंठमुदुली बिल मुव करछन्ती ये चिट्ठी लिखा है कंठमुदुली ऑलरेडी आसाइलानी घर को पैरोल रे आसी 28 तारीख दिन पहुंची 12 दिन पे आसी पैरोल रे 10th एनिवर्सरी ऑफ द
ये जो
बेल कौन दिए
डॉक्यूमेंट जो आनेस करते से जेल को लिखि देथले एटा
पड़े भला
ये सला
छाड़ी देला और कौन
ठंडा सिगले जा गुड
लेखन वो आई एटा फाइल कर देंगे
677 of 2025
IN number 677 of 2025 there is an application for interim bail on the ground that the grandmother of the this is an application for bail filed by appellant number 2 Konthamudil. On the ground that the grandmother of the petitioner has expired on 28 to 2025. The Land Council for the state has obtained written instruction from IIC of Yasamunpur Police Station, East Koraput, that the petitioner has come to his house on 28 to 2015 for the 10 days death anniversary, bracket लिखते to 10 कार्य, and stay for 12 days and to return back Koraput. The letter produced by the sponsor state council is taken on record. In view of such letter, this interim application is disposed of.
रेगुलर बेल हियरिंग प्रोसेस में
এটা অলগা ইয়ে করিবেন আপনি এইটা আজি আসছিলা কেবল এইটি পাই
yes sir already bail application is there lordship में fix a date
you file a memo tomorrow it will come next week yes
Item 4.
Ishwarjiya Das.
So, on Ishwarjiya they joined in the state panel that
No, no,
that is
no.
another
किए जोना पड़े
in the chamber of Mr. Sogat Das, because last time also adjournment was taken. Anything one has to find. Just file wakalatnama on behalf of the accused. I don't think he has 10 years. ତାକୁ appointment ହେଇଯିବ 21/5 କେତେ ବର୍ଷ practice on the .com
21/5 ରେ
21/5 ରେ she has been appointed. She is not coming.
ଜଣେ ଐଶ୍ୱର୍ଯ୍ୟା ଦାସ ଅଛନ୍ତି ନା ଆଉ
2 ଜଣ ଅଛନ୍ତି.
ନନ୍ କ୍ଲିକିଂ ଥିବ ତାର
ନାଇଁ because last date ରେ ତାଙ୍କ chamber ରେ ଆଉ ଜଣେ has taken time.
କି କୋଉ chamber
5/11/2024.
कुलदीप महांती
ହଁ ବେଲ ଶୁଣିଥିଲି ତ ଦେଶ appearance ହଏନ. Anyway, we keeping it to another date. No ଆସିଲେ we will appoint somebody. ତା ଛଡା 10 ବର୍ଷ ନହେଲେ also
ନାଇଁ 10 ବର୍ଷ ଦେଇ ହବ ଲେଖି ଦଉ non appears for the appellant put up this matter in the week commencing 17 okay 7 2025 yes
we come the 70
डेट तो दे दो ऑफर दे दो ना 17 थे
18 दे दी
18 लिस्ट ऑन 18
this matter on 18 yes
Item 5.
As per last order, my lordship received written instruction from the IIC, Bhadrak Police Station.
This had been sent to the informant.
It has been served.
Served.
Because that was served on 16 to perhaps give a little longer time. So that he can. Anybody has appeared? Nobody. So you are moving for bail.
My lord.
What is the offense for which the appellant has been?
Offenses, my lord, 376(2) and section 6 POCSO, my lord.
You, but not now. Yes.
May I please, Your Lordship? I am appearing on behalf of Mr. H.S. Smith, Lord. Sir, I have filed an IA, my Lord, for interim bail of the petitioner.
IA 380.
Yes, Lord.
Interim bail on what ground?
My Lord, the wife and children of the petitioner are badly in need of medical treatment and financial assistance, Lord. The petitioner is in custody since.
No, who is ailing?
My Lord?
Who is ailing? Your wife?
No, depression was in custody.
Depression to habo.
3 children.
Upon kabe mo wife depression rachi. Can that be a ground? You have been
You are in custody since when?
25 July 2016.
25 July
2016.
No, what happened to your regular bail application?
Rejected.
Oh, rejected. 11/9.
11/9/2024.
Oh. Oh, it's a case of double murder. Oh. The weapon that was used was axe. Eyewitnesses are there.
Brother is yes.
And craniocerebral injury. So
Brother and father.
chop wound also there on the neck. So this is multiple chop head injury, injury to the brain, so on. So it is a 4-page order we have discussed, and it was rejected in September. So obviously there is no change in the circumstance except saying that my wife is under depression. That cannot be a ground to reconsider this bail for bail within a period of 4 to 5 months. In September, your bail was rejected. 5 months have just passed, and you are taking a ground that my wife is undergoing depression.
To that effect, the medical report is not there.
About the element which you are telling, there is no medical document. He is rightly pointing out. You have not annexed any medical document. So,
Till date, the petitioner has not been released on bail, madam. It's been almost 8 years.
all those things were considered in September, and you have got 3 children.
Yes, madam.
One is aged about 19 years, the other is about 17 years. So they are there to support you. It's not that nobody is there in the family. By the way, you take instruction on this, particularly on this paragraph number 3. Let us see that. 3 and 6 on this interim application stated. The IN number so and so, this is an application for interim bail. The land council for the state was received the copy of the interim application 6 times to obtain instruction, particularly with reference to paragraph number 3 and 6. Put up this matter in the commencing 17 तारीख रखियो 18 तारीख 18 March 2025.
Item 7.
Prior to submission advance by learning senior that matter may be taken of some other to the underlying advocate general to address on this issue.
Why? What is it?
In this matter, I have to inform madam. I have received the paperwork yesterday.
No. Advocate General is there. Which what murder? It's murder case.
Murder case. That's a
Manga.
Oh boy. Oh, just silent.
I received paperwork yesterday. The connecting material postponed to 24th March. 1066 in this appeal 1066 and 1077.
No. I find that there are a number of 8 appeals.
So 2 more are left out.
And 2 more are there 1066, 1067. It is not in the list.
ସେଇଆ ତ ପଚାରୁଛି left
କୋଉଟା ଆସିନି କୁହନ୍ତୁ ଆମେ
1066 1067 ପୁରା 24 ମାର୍ଚ୍ଚ କୁ ଆସିବ
1066 पर ଅଛି
67 ଅଛି 64 ବି ଅଛି
ଆଉ କଣ କହୁଛନ୍ତି
ସେଟା ଆଡଜର୍ନ ହେଇଥିଲା 24 ମାର୍ଚ୍ଚ କୁ
ହେଲା ଆସିଛି ଏକା ସାଙ୍ଗେ ତ ଶୁଣାଣି ହବ
ଆଉ କିଛି ରହିଯାଇଛି
ଆଉ ରହିନି କି
ଠିକ ଅଛି
ଇଏ ଆକ୍ୟୁଟେଲ ହେଇଯାଇଛି ଅରୁ
ଜଣେ ଆକ୍ୟୁଟେଲ ହେଇଛି
and ଚୈତନ୍ୟ ସେଠି ଆକ୍ୟୁଟେଡ
ଅରୁ
ଆଉ ଚୈତନ୍ୟ ସେଠିର ଅପିଲ ଅଛି ଆଜି
ତୁମେ କାହା ସାଙ୍ଗରେ ଗୋଟେ ଥିବ ନା ଗୋଟିଏ ତ ଆକ୍ୟୁଟେଲ
total number of persons faced trial is Mr. Panda and there are 10 and
One acquitted.
One was acquitted.
One was acquitted means 9 and 8 ଟା କପି ଦଉଛି।
ଆଠ ଅଛି ଗୋଟେ ଆଇଦର ଆଙ୍କ ସାଙ୍ଗେ ଅଛି କି କୋଉଠି ଗୋଟେ ରହିଛି।
କୈଳାସଚନ୍ଦ୍ର ଖଟୁଆ ସାଙ୍ଗରେ ଅଛି।
ଆଚ୍ଛା ତା ସହିତ ଅଛି ନା।
ଆଜ୍ଞା।
କ୍ରିମିନାଲ ଅପିଲ 1067 ରେ। ହଉ ହଉ। ତା ନା ଚୈତନ୍ୟ।
Paper book has already been prepared.
Marked.
It is stated that when an advocate general is to ask with the matter. କେବେ କୁହନ୍ତୁ ରଖିବ? 24 ରେ posting ଥିଲା।
The bail matter.
Next week thou
Next week.
the bail matter.
So
No, let it not be next week. Next week I am.
So till a date, you give us, you see, ask the learned advocate general and take the council's consent so that we, you give the date, we will fix on that. Mr. Panda, just let him.
नहीं 17 में 19 की 20 जो
Please take the,
I'll
just
take it.
intimate if it's free on that day, so there is no problem. Just give
19
that.
or 20
All right.
କଣ କହିଲେ?
19 or 20
हाँ, see, पचास दिन learned advocate general यदि free थे तो yes.
okay well let it be 21st absolutely
Mr. Panda, just let him ask the learned advocate general.
let it be 21st that would be
Yes.
19th and 20th I was
No, all right. 21st if he is not available 24th.
24th
24th को थिला 24th
24 तारीख तो अच्छी केस
24 तारीख तो अच्छी।
हाँ तो 24 करो
We are fixing the date. Release this matter on 24th. We commencing election पूरा पकेंगे 24/3/2000 ये। अच्छा गुट्टे कर लिखी देवे तादर लिख देव with swan so swan. Yes, next.
this is coming up for orders on 24th
New orders. Yes.
order of the advocate
Item 8.
Yeah.
Madam, decision of appeal against the acquittal matter. The last occasion, Lordship direct to take instruction whether any appeal has been preferred at the instance of appeal, acquittal, but report comes, no appeal has been preferred.
Okay, just give that report.
The report is there in the file noting they have given.
ଆପଣଙ୍କର oral submission note କରିବୁ ଆପଣ କହୁଛନ୍ତି।
As per the recorded by the concerned branch. AG officer branch as inquired from the office of the advocate general, no appeal filed by the state government against the order. They have provided, but instruction, written instruction, they know they let it.
ନା ନା as found out from the office of the advocate general କଣ proposal ଅଛି କି director
That
prosecutor?
instruction.
What the proposal? There is any proposal?
And that's why I say that some other
proposal
day.
ନହେଲେ କେମିତି ଆପଣ ଫାଇଲ କରିବେ? ସେ ରୁଟେଡ ହୁଏ ସେଠି ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ଥ୍ରୁ ରୁଟେଡ ହେଇକି ଯିବ ତାପରେ ଆସିବ ଗ୍ରାଉଣ୍ଡସ ଦେବେ ଏଜି ଅଫିସ କୁ ଆସିବେ ଏଜି ତାପରେ କାହାକୁ ଇଣ୍ଟରେଷ୍ଟ କରେଇବେ ତାପରେ ଦେଖିଲା ପରେ ଫାଇନାଲି ଯଦି ଓକେ ହେଲା ପୁଣି ଏଗେନ ଲ ଡିପାର୍ଟମେଣ୍ଟ କୁ କନସେଣ୍ଟ ଆଣିକିନି ଫାଇଲ ହୁଏ। तो आपनकर प्रपोजल अछि कि नै we want
That's
to
why I pray for some other day.
It's all right. There is no problem. देखि दियंतु the learned council for the state seeks some further time to obtain instruction as to whether there is any proposal from the side of the state to challenge the judgment and order passed by the learned additional session judge Gunpur in criminal trial number 109 of 2016 in acquitting the respondent number 2 Santosh Kumar Naik of all the charges कर दूं केबे रखिबा कहंतु
Next week.
Like next week ने out week नहीं होता जहाँ आनिबे in writing आनिबे हला we commencing from 17th of March 2025 learning council for the petitioner is present for them
You are Mr. Mahanti?
Madam.
all right
Item 10.
has obtained written instruction from Superintendent District Jail Balasore dated 21/2/2025, which indicates that the appellant was not inclined to prefer appeal against the judgment and order passed by the 11th Session Judge Balasore in Sessions Trial number 248 of 2010, in which he was found guilty under Section 302 of the Indian Penal Code. Judgment and order dated କରନ୍ତୁ 21/3/2014 and sentenced to life imprisonment. The documents produced by the Land Council for the state are taken on record. The report has been submitted by the
District Judge Balaram also sent the report.
District Judge report.
Page 32.
Page 32.
एका जिनिଷଟା report call କରିଥିଲେ superintendent ଏଟା ଜଣେଇଦେବେ.
All right. The learned district judge Balasore has also submitted its report dated 22/2/2025, in which similar reason has been assigned for non-preferring the appeal by the appellant. So, IA number
SOP 2023 ରେ ତାର ଇଏଟା ବି
Acha.
ଚାଲିଛି ସେଟା
It further appears that the
33 ରେ
33
last paragraph ରେ ଲେଖା ଅଛି.
ଭିତରେ
ହଁ ମାନେ ସେଇ ରିପୋର୍ଟ ସବୁରେ ଅଛି. ସେ page 13 ରେ district judge ର report ବି ଅଛି.
it further appears that the superintendent has sent the premature release proposal as per new SOP-2023 to the DG of Prisons and DCS Orissa Bhubaneswar on completion of 14 years of sentence of the appellant. After IN number so and so. This is an application for. Have you filed any application for condonation of delay?
I'm on behalf of Mr.
Stop. A mention is made on behalf of Mr. Gopal Krishna Naik for adjournment. Place this matter in the week commencing from 17th March 2025. You see, this man, whatever it may happen to his sponsor, this jail criminal appeal has been filed and he has been interested. So he should take some steps because it is condonation of delay is there. So some steps have to be taken. But he has been engaged
by the council or by the court.
I'll inform him that
Just 1 minute.
He has been appointed as amicus curiae. Formal application, what is the law? 18 through ରଖୁଛୁ ଆପଣ 18/3/2025. Yes.
Item 12.
Well, item 12 is this petition has been filed against the rejection of the petitioner's application to discharge him from a disproportionate assets case.
Which is the impugned order, Mr. Mahanti?
Before going to that is what I am saying. Before going to the impugned order,
Let me take your lordship, if you wish lordship's permission, to page 305, Lord.
305.
That is immediately annexure 11.
Yes.
Your lordship got.
Yes.
Today has been fixed for hearing on the discharge petition, and counsel for the accused petitioner drew the attention of the court that before going to the question of law, the factual details of the case record voluminously fixed that there has been some patent defect and some scrupulous discrepancies that have been suppressed in the charge sheet submitted by the RO. The percentage of DI calculated by the prosecution with a copy to the prosecution. However, during course of argument, learned special PP factually admitted certain income to have been ignored by the fallacy in the investigation, with an argument that can be cured during the course of trial. As such, in the said juncture, before disposing of the said petition, both on question of fact and law, while zeroing my attention on a prima facie material to proceed with the trial, it would be legally congruent in salutary obligation to the statute before advancing to the next stage of trial, when the accused petitioner have offered an explanation to the satisfaction of the requirement under PC Act as stipulated on section 31 and 13E of the said Act, to all for a written rejoinder from the state where the prima facie material is questioned by the counsel for the accused petitioner with documentary evidence. As such, the prosecution is directed to file a written reply with the further direction to the IO of the case to assist the prosecution and to remain present on the date fixed to meet the queries and claim tendered by the counsel for the accused before jumping into an above conclusion in forcing a trial upon the accused petitioner in a routine and mechanical exercise of discretion on working legal wisdom. Whatever it is. Then we have page 308. This is the written reply of the
308
prosecution.
Yes.
And except 12. Has your lordship got it?
Yeah.
The prosecution most respectfully begs to state as follows. The prosecution has filed the objection on 21/6/2016 to the petition of the accused filed under section 227 CRPC that all the plea and claim are inherited and found to be not sustainable. That the prosecution submit the reply to the claim of the accused as follows. Claim of salary from Calicut College for the period 679 to 1079. As per the letter that the principal college, the accused has received salary from 1/11/79 to this amount into which has been taken in the CS. Claim that means from one as Calicut College admittedly served in that is a government college, 679.
The question is that whether you have got the salary for that period or not, because that would be source of income.
Yes.
So, but suppose you are serving, but suppose there is no salary has been paid during that period, which you might have received later on. Check period bhitere ଆପଣ ଯଦି salary ଆସିନି
then ଏଇ ପିରିୟଡ ରିସିଭ୍ କରିଛି ମୁଁ salary. ସେମାନେ salary statement ବି ଆଣିଛନ୍ତି କିନ୍ତୁ ଏଗୁଡାକୁ calculation କୁ ନେଇ
By the way, Mr. Mahanti, we just want to know what is the disproportionate amount
total.
ମାନେ final as per charge sheet.
171, I get it.
Yes.
1,71,000.
No, 171%.
Correct. 1,71,000. Oh no.
171% as per ये page रे अछि
page 266.
No, just amount.
Page 266.
Amount कहूଛି.
Page 266. Last line, your lordship is correct.
263.
Last line, not disproportionate. I should therefore calculate.
It is 42 lakhs.
Yes.
It is 42 lakhs.
And 171%.
171.
And check period is June 1978 to 26 June 2008. The date of.
No, Mr. Das, I found a table. It says as per the FIR it is 42 lakhs. As per the charge sheet it is 31 lakhs. So that 171 is reduced to 121. Is that wrong? That is at page 302 of the brief. That is part of the analysis. Oh, not taken into account by prosecution. But
ଏଇଟା ନୁହେଁ,
ଏଇଟା ଆପଣଙ୍କର
ଏଇଟା ମୋର
ଯେ but as per the charge sheet ତ ଥିବ କଥା ଏଇଟା ଚାର୍ଜ sheet ବି ଆପଣ ନିଜର ଦେଇଛନ୍ତି ଇଗ୍ନୋର ଟା ଦେଇଛନ୍ତି 1 2 3 4 କରିକି ଚାର୍ଜ sheet ଟା ତ ଆପଣଙ୍କ version ନଥିବ it must be version of the prosecution.
Disproportionate asset as per charge sheet is 47 lakh.
My lord.
21,000.
ଏଇଟା ଆପଣଙ୍କର ଆପଣଙ୍କ ନିଜର ଇଏ
ହଁ ଏଇଟା ମୋ calculation ସେଇ
ଆହୁରି percentage ବଢିଗଲା.
So how do you say, Mr. Mohanty, that at this stage when the discharge petition is under consideration, such a huge amount
ଯୋଉଗୁଡା admitted ସେଗୁଡା ତ କାଟିଦେବେ
ହେଲେ ବି କଣ ଏଇଗୁଡା ପଳେଇବ 47 ଲାଖ ଯେ କମ ଆପଣ କେତେ କହୁନାହାନ୍ତି ଯୋଉ admitted amount ଯୋଉଟା କହୁଛନ୍ତି କେତେ ଆସିବ
ସେଟା ଗଲେ ବି ହଉଛି
ଯଦି ହଁ ଗୋଟେ ଆପଣ ଯୋଉ 1 ଲାଖ କହିଲେ ମୁଁ we are shocked that as 1 ଲାଖ ପାଇଁ କାହା ଗୋଟେ disproportionate asset ରେ trial face କରିବା
ସେଟା 171% ସେଥିରେ ସେ କହୁଛନ୍ତି main explanation is that my son was serving and his son has given money for the construction of the house and other things also. That has not been taken into consideration.
That
totally,
that would be a matter of trial because your son, suppose he's serving somewhere, his expenses also would be taken into account, and whether he was contributing to you or not, it is to be also proved in that way. Because suppose some account money he has sent to you, so merely because your son is earning, that cannot be a ground. It is the burden is on you, and that stage has not reached. That stage that my son is serving and he was also earning, so that is not.
ଏଇଗୁଡା ଯୋଉଟା investigation ବେଳେ ଆମେ ଦେଇଛୁ, they have not taken into consideration those things.
Mr. Please see page 251. They have not taken into account Chinmay Chirasundar Mishra's income because they say he was staying in Chennai. And Tanmay Sarup Mishra also, when he was staying in Bangalore, that part has not been taken into account.
Total tonkata
But Bhubaneswar jo rahila, that has been taken into account.
They were getting salary in lakhs. Total tonkata Bangalore ରେ ଖର୍ଚ୍ଚ କରୁଛନ୍ତି ନା ଘରକୁ ଯାହା ପଠଉଥିଲେ ସେଗୁଡା
ସେମାନେ ବାହା ହେଇନାହାନ୍ତି କଣ
ପରେ ବାହା ହେଇଛନ୍ତି
ଫ୍ୟୁଚର ପାଇଁ ରଖୁଥିବେ କଣ ହଉଛି ଏଗୁଡା ସବୁ ଆସିଯିବ ଏଭିଡେନ୍ସ ର ଜିନିଷ ବାଙ୍ଗାଲୋରରେ ଯିଏ ରହୁଛି
ସେଟା at the relevant point of time they were not married.
And ବାପାଙ୍କର ଚାକିରି ଥିଲେ କଣ ପିଲାମାନେ ପଇସା ପଠେଇବେ
ଘର ତିଆରି କରିବାକୁ ପଠେଇବେନି କି
ଘର ତିଆରି କରିବାକୁ ସେମିତି ଦରକାର କିଛି documentary evidence
that has to be shown.
That is at the time of
ଏଇ stage ରେ discharge stage ରେ ଆମେ ଯୋଉ ହଁ ଆପଣ you are right that suppose ଗୋଟେ admitted ଜିନିଷ ରହିଛି ଯୋଉଟା କି ତା ପାଇଁ evidence ଦରକାର ନାହିଁ ମାନେ ସେଇ ଜିନିଷକୁ consider କଲେ ଆପଣଙ୍କର disproportionate asset ଟା ହବ ନାହିଁ that is a different matter otherwise if it requires that
ଲେଖିଛନ୍ତି ମାନେ ଲେଖିଛନ୍ତି
wife କର ବି explain କରିଛନ୍ତି କାହିଁ they have not taken.
ଏଇଟାରେ 344 ଲେଖିଛନ୍ତି କୋର୍ଟ ସେ
344
admittedly it is found that some of the salary received by the accused of different periods during the check period are missing, but it appears that if such amount is squared out the DA as shown against him, still then a huge amount remained as DA. With regard to other aspects like the income of the sons of the accused and agriculture are only to be gone into at the time of trial. It is further stated huge difference found between the house rent shown by the prosecution and the accused, which can only be calculated during the trial. It is further that the accused had filed the income tax return was added
ये जेमती गोटे इलेक्शन रे माने ह्यूज मार्जिन ने जने जितु आसीबो आज्ञा ए पर्टिकुलर बूथ रे केतोडा वोट ये हितला तो इसे टेक हो गई तो सीटा को भी काउंट कले भी जदी कार रिजल्ट रे किछि ये करबनी से ये टेक हो जाउछि आपनकर किछि इनकम जदी भी आपनकर सैलरी रो नहीं नाथी सो सेटा एते अमाउंट नुहे जी जोटा कि 47 lakhs रो डिस्प्रोपोर्शनेट को ये करे दो By the way, what is the stage now?
It charges hey
So some interim order has been passed.
it's a nice
Interim arrangement wise set up the
interim arrangement manu na
whether the charge has been framed.
ना
एक फाइल कर दूथिबे हाई कोर्ट रे पेंडिंग अछि जे बडे दूथिबे तो
6 तारीख दिन अछि चार्ज फ्रेम करियो
so let the charge be framed and you face the trial and anything further, Mr. Mahanti?
So that basis is
Are the learning Mr. Ashok Mahanti, learned senior advocate for the petitioners, and Mr. Das, Lenin. It is senior standing
Only say standing counsel.
Standing counsel for the Vigilance Department. The petitioners, Vibhuti Bhushan Misra and his wife Sodhamini Misra, have filed this petition challenging the order dated 27/1/2024 passed by the London Special Judge, Special Court Bhubaneswar in PR number 8/45 of 2015/2013 in rejecting the petition filed by the petitioners under section 239 of CRPC for discharge. As per the charge sheet, which has been annexed to the petition,
Page 220.
page number is
220.
220. The disproportionate asset amount is
At page 266.
56.
Last line.
47,21,524. Mr. Mahanti Land Counsel for the petitioner submitted that admittedly some salary amount salary received by the petitioner number one who was the she कौन थिले से
retired special secretary
who retired are the special secretary
finance
has not been taken into account.
ना अच्छा check period रे कौन water resources check
check कर दिया account section water resources
finance
अच्छा इनकी को during the check period the petitioner number one was whom हमें gap दे दूँ जो अपन पहले it further submits that the petitioners are having three sons and two sons and their income has also not been and they have contributed for the construction of the house and the same has also not been taken into account. So far as non-taking of some of the salary of the petitioner number one is concerned, Mr. Mahanti fairly submits that if such amount is taken into consideration, the there would be still disproportionate
salary ଟା କିନ୍ତୁ ପୁଅର ଯଦି ନେବେ ତାହେଲେ
ଆମେ କହୁଛୁ କି ଯୋଉ salary of the
ଆଜ୍ଞା।
petitioner number one, there will be still disproportionate asset amount. However, if the income of the two sons of the petitioner are taken into account, there will be no disproportionate asset. However, we are of the view that what was the income of the two sons, how much amount, whether they were contributing anything for the construction of the house, and what was such amount, are all the matter of evidence, which if adduced during trial from the side of the petitioners, will be adjudicated by the learned trial court in accordance with law. At this stage, to give some of the decisions and the principle of discharge, and we do not find that any ground to interfere with the impugned order. Accordingly, the CRLMP being devoid of merit stands dismissed. The interim order, which was passed on 14/8/2024, on first time passed it like that. That was passed on 21/10/2024. Stands vacated. The learned trial court shall do well to expedite the framing of the charge. Yes, next.
ଏଇଟା ଥିଲା ସିଏ
ଆପଣ ଦେବେ
ଚାର୍ଜ ସିଟ୍ ଅଛି ପେଜ 120 ରେ ଫାଇନାନ୍ସିଆଲ ଆଡଭାଇଜର କମ୍ ଆଡିଶନାଲ
କୋଉ ପେଜ ଟା ଟିକେ କହିବେ
120 ରେ
120
ରନିଂ ପେଜ ଚାର୍ଜ ସିଟ୍
ହଁ ଏଇ ଯୋଉଟା ଲେଖିଲେ ନା ଫାଇନାନ୍ସିଆଲ ଆଡଭାଇଜର 120 ପେଜ ଅଛି କମ୍ ଆଡିଶନାଲ ସେକ୍ରେଟାରୀ ଟୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ୱାଟର ରିସୋର୍ସେସ ଡିପାର୍ଟମେଣ୍ଟ ଭୁବନେଶ୍ୱର। But Mr. Das, in the cause list, it is mentioned senior standing counsel.
Inadvertent.
Oh, yes. So, option zero counsel options. All right.
Lordship permits for less submit one for notes. My Lord found it is an urgent matter, otherwise it's difficult to resist temptation for going to TV loans.
Is it?
It's difficult to resist the temptation of going to television. That's it.
Right, so, there is some matters in the single.
My item 30 was
no, we'll take up tomorrow.
Yes.